All right, go ahead.
Your Honor, his first client is Jerry Clark, this is 25 CF 2252. He's asking to continue this for depositions and potential motion practice.
Our depot's set.
I do not have a message that the depots are set in that, Judge. I think he was engaging in negotiations with the state attorney's office.
Okay. 6/22, 9 o'clock.
Your Honor, his next client is Jonathan O'Shea. This is 25 CF 770.
Okay. Just a second. All right, go ahead.
It's my understanding that they are waiting on some information from the alleged victim on that matter. And I believe there is a offer on the table that needs that information. Does that sound right?
That is correct.
Should we leave this on for the docket day?
She did not appear for her deposition, so we're trying to follow up with her. Yeah, could we leave it for a docket day without subpoenas?
Yeah.
Looks like a drop charge affidavit was just filed too.
And so I think that may resolve it.
All right, you want to do May 4th without subpoenas?
Yes, Your Honor.
Let's call that plea or continue May 4th, 9 o'clock.
Unless you want to dismiss it now.
Just follow up.
Understood. Your Honor, I'm also covering for Mr. Gil Powell. I don't know if he had anything on the docket, anything else on the docket. Odyssey is down. I cannot confirm.
I'll have to take a quick look because, as you know, they all show as Gil Powell the second or third or junior. It seems to be different every time. So I don't see anything for Gil Powell, but I do see Dixie.
I don't have any information there.
Okay.
I mean, I can go ahead and do it just to do it.
Well, we'll see if he arrives.
Very good.
I know there's a lot of court going on across the circuit today. So
Your Honor, that's all I have before the court may be excused.
yes, sir. Thank you. All right, Mr. Flowers, there you are. Didn't see you over there.
I believe my list is accurate. The first case I have is Wise 24 CF. I believe it's 1362. Does that appear on your?
I'm flipping to get there. Here.
That's a
Go
case I
ahead.
have with Ariana Leone, and we anticipated a motion by the state being filed today, but she's not here. And so we would just set it for trial.
Okay. You know what kind of motion that was? What kind of motion was being anticipated?
No pros.
Oh, well, it's not federal court. You don't have to move the court to dismiss.
I don't see that in the system yet. I will follow up on that, and for now, we'll just leave it for trial.
Okay.
Judge, the next matter I have is 25 CF 1374 State v. Elmore. There is I think, another case.
If I could, real quick, Mr. Flowers. So Wise will be set for 5/4 at 9 o'clock.
5/4.
I'm putting it on the trial list, but
Thank you, Judge.
if it gets resolved in the meantime, it'll come off the docket.
Very well. Judge, the next matter I did call was Elmore.
All right, go ahead, sir.
There are two cases. There was one that we've been dealing with, and subsequently, there is another.
Is that also in my division?
It's in your division, Your
Okay.
Honor.
It has not been filed on yet.
You're gonna file on it, though, right?
That's the plan.
Judge, the state may or may not file on it, we don't know, but I'm going to suggest that we continue this, because if they file on the new case and they run together, that might be the most efficient way to handle it. Does that make sense to you?
Yes, it does.
For some reason, it's on my paper docket. It's not showing up here. Give me just 1 second, Mr. Flowers. Oh, he's an inmate. Do y'all want to bring it back on Wednesday? I'm assuming if he's got a new case, there's a chance of that, but I didn't think about it. Do y'all want to bring it back Wednesday or just make your moves from here?
Just, Judge, I met with him yesterday. He knows what we're doing today.
Okay.
State's fine with it being handled today.
Thank you.
All right, let's put him, that one is already set for pretrial on 6/22. Let's make sure it's 6/24 since he's an inmate at 9 o'clock.
Thank you, Judge.
All right. And that new case is 26 CF 715.
The next I have is 24 CF 2179. The defendant's name is Frazier. Judge, because it's my fault, I need to ask for a continuance. I know,
I think we had a lot of discussions about this case last time around.
we did,
So why do we need a continuance again?
because I meant to and did not. The victim in the case's deposition hasn't been taken. It's my fault. It's not my client's fault, and it's not the state's. That falls on me. However, Judge, if you put it on for trial for the week of the 18th, I'll endeavor to do my very best.
It's gonna be, Mr. Sheik's case, however, we have no objection to the victim getting deposed. And we can try to get Mr. Flowers, I would assume that it would take, 30 minutes, Mr. Flowers.
Tops. But if we had,
How long of it? I'm sorry, go ahead.
if we set it for the 18th, Judge, understanding that the problem was caused by my office, we'll endeavor to get it done prior to the 18th.
How long of a trial do you think it'd be, Mr. Flowers?
2 days.
2 days?
State agrees.
Let's see you back on May 4th.
Yes,
At
sir.
that point, let's talk about that deposition, and has it been set?
Yes, sir. Next case is Schneider, 25 CF 1627. We're asking that this remains set for docket day with every intention of disposing of the case that day.
Okay. May 4th, docket day, 9 o'clock. Put it as P or C.
That's what we anticipate will happen. Final matter that I have, that I see, Your Honor, is Win, NGUYEN, 25 CF 2427. I'm anticipating 5-4, if you were to put it on soft, that we will be able to handle this matter on that date and time.
It's only the second time up, 5-4, 9 o'clock.
Yes, sir.
Clear, continue. Anything else, Mr. Flowers?
I don't believe so, Your Honor.
Covering for anyone else?
Well, myself and Mr. Shaw, that's it. Thank
I
you,
didn't
sir.
see Mr. Shaw, but okay. All right, then we'll see you on Monday for Frazier. All right, next is going to be I think it says the defendant is Sherry Meyer, so is that Mr. Patel?
Yes.
Okay.
Good morning, Judge.
Good morning.
If we can approach on Ms. Meyer's case, it's
Okay.
23 CF 2740.
All right, so Sherry Meyer is gonna be June 22nd, 9 o'clock, last continuance, for the reasons discussed at the bench. All right, Mr. Gilbert. Morning.
Two cases, first Michael Griffith in 26 CF 74. We have a waiver. It's first time up, we request a continuance. I owe Mr. Sick some information on that.
All right, June, it's first time up, June 22nd, 9 o'clock.
Second case is Randall Thibodeau in 25 CF 2039. We have a waiver. We're close to a resolution on this, so I'd like to, I need to talk again with Mr. Sick. I'd like to leave this set without subs for Form A.
Without objection.
All right, May 4th, 9 o'clock, clear continuance.
That's all I have, Your Honor.
All right, thank you. Have a good day.
Yes, sir.
Mr. Madden.
Here on behalf of Richard Hawthorne.
There we go. Okay. What are we doing, Mr. Hawthorne?
We've got depositions set, I think, the second week of May, so I'd be asking for continuance in order to get those completed.
All right.
Objection.
All right, June 22nd, 9 o'clock for pretrial conference to conclude depots. All
Thank you very
right,
much,
thank you,
Your
Mr. Madden. Have a good day. All right. I don't see Mr. Cobb. So I guess, Mr. Patel, you're back up.
Thank you, Judge.
Go ahead.
Jay Patel on behalf of Brett Morris, 25 CF 1360. This case was in FTA status for quite a bit of time, and I just took the case back over. I've got the paper discovery, but I don't have the body cameras, so I'll be in touch with Mr. Sprouse about that. While he said that the discovery was shared, I just looked again on my internal folder and don't see the videos, so.
Mr. Sprouse, are you aware?
Yes, it was shared 35 days ago and downloaded. He has 954 days to download it. again.
954?
Correct.
So if we can continue the case, I'll get in touch with his office and figure out where those videos
All right, June 22nd, 9 o'clock. That's kind of pushing this one a little bit. It's going to be a year old almost at that point.
are. I think it was an FTA status.
Oh, I understand.
Okay.
I mean, I don't want to get into it, but who failed to appear?
He was in jail.
Okay. So, all right.
I think he wanted to be here. Next, Jay Patel on behalf of Cameron Stewart, 25 CF 1862. If we can set this to 622 for Ms. Basso and I believe that we'll work to come to terms on a PTI. Otherwise, I'm getting the depositions set, and hopefully we'll have those heard before the next retrial.
There's no objection, Your Honor.
All right, if it's not going to be PTI, let's get those depots done beforehand. It's cases from September.
And then finally, Jay Patel and Brandy Merrifield on behalf of Zachary Clapper, 25 CF 2166. Ms. Merrifield and I need to finish up a specific discovery request relating to file downloads from the devices before we did the depositions. That should get filed by the end of this week.
What needs to be filed?
A specific discovery request. There's just quite a bit more of phone downloads that we anticipated having, but we need to request.
All right, whose case is that for the state?
Ms. Leonis, Your Honor.
Okay.
As soon as we see the specific discovery request, we'll see exactly what's missing and go ahead and get it to them.
All right, let's get that done in the next month or so, June 22nd, 9 o'clock.
Thank you, Judge. I believe I have nothing further, maybe excused.
Yes, sir. All right, Mr. Durrell. Y'all really went off the rails on signing up here. It started going defendants and lawyers on the other side. Looks like you're representing each other.
Morning, Your Honor. May it please the court, Justin Durrell. Your Honor, I have Mr. Reginald Bradshaw, 26 CF 156.
Give me 1 second, Mr. Durrell. Go ahead.
Your Honor, I request a continuance for Mr. Bradshaw.
I believe it's the first time up.
Yes, Your Honor.
Okay.
No objection from the state.
June 22nd, 9 o'clock.
Your Honor, next is Mr. James Kaufman. Your Honor, I need to request a continuance for Mr. Kaufman. There is some discovery that I do not have. I did bring this up to Ms. Barrickman back in depositions. And
What discovery do you think is missing? This is a December 24 case. We've had a motion to suppress already,
Yes, Your Honor. So
or motion to dismiss, I think.
one of the files in the discovery that was given to me is the text now subpoena and results. That file is empty on the discovery that was provided to me. I did discuss that with Ms. Barrickman when we did deposition. She said she has it. I'll be honest, Your Honor, I let that fall when I got focused on the motion to dismiss. I discussed that with Ms. Basso this morning. She's gonna look into it and see if she can give me that subpoena.
Is this part of the second conversation or whatever? Wasn't there like multiple different conversations allegedly?
So supposedly, all of the communication was done through this like third-party app, the Text Now app. And that's how law enforcement identified Mr. Kaufman and tied them to the conversations.
Okay.
So I do need to look at that subpoena, Your Honor.
Your Honor, I should have an answer from Mr. Durrell either by the end of court today or tomorrow, and if it's there, I will get it right to him. And if not, I'll hunt it down.
Is this your case now, Ms. Basso?
No, Your Honor, it is Ms. Leone's case.
And Your Honor, I do understand this is getting very old. This will be the last continuance.
Well, also just based on the kind of procedural posture we were in last time around, that we had the motion to dismiss, and then there was talk about separate conversations. And I just want to make sure you have everything, because obviously there's a huge difference if there's other conversations that they haven't turned over, even if,
I believe we have all the conversations. It's just that subpoena I think is missing, Your Honor. And like I said, I did discuss that with Ms. Barrickman back in the day. It is my fault. I didn't follow up with that when I got focused on the motion to dismiss. I apologize.
all right, June 22nd, 9 o'clock. I'd like for that to be the last continuance.
Understood, Your Honor.
All right. All right, who else do you have, Mr. Drew?
Next, I have Ms. Nina Gainey. Ms. Gainey? And Your Honor, if I may approach, Ms. Gainey is going to be playing into the PTI program
Sure.
today.
You can approach.
PTI agreement is behind that.
Thank you.
Actually, I think I give the PTI agreement to.
You do, but I have to look at it first. I'll give it back once I've had a chance to
Yes,
look
sir.
at it. All right, Ms. Guinea, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes,
Can you state your full name and date of birth, please?
Nina Ann Gainey, 10/7/84.
You can put your hand down, Ms. Gainey, thank you. You're here in 25 CF 2016, where you're currently charged with child abuse without great bodily harm, which is a third-degree felony and punishable by up to 5 years in state prison. Do you understand that?
Yes,
I've been handed a plea and sentencing agreement that would have you enter into the PTI program as part of your plea. If you successfully complete the PTI program, you'd be allowed to withdraw your plea and the state would dismiss your case. However, if you fail to successfully complete the PTI program, we'd go straight to sentencing. Do you understand? Okay, so that means that if you don't do what you're supposed to do as part of this agreement, that you'd come back and I can give you anything up to 5 years in prison. Do you understand that?
yes, sir.
All right. Have you had a chance to go over the plea and sentencing agreement with your lawyer?
Told me to
Yeah, that's what we spoke about this morning.
Yes, sir.
Is that your signature on there?
Yes, sir.
All right, so did you go over this agreement with him?
Yes,
Okay, did he answer all of your questions?
yes.
Do you need any more time to go over the plea and sentencing agreement?
No.
Did you also go over the pretrial intervention agreement with your lawyer?
Yes.
Okay, is that your signature on there?
Yes.
So you've reviewed this?
Yes.
All right, and did you understand all the terms?
Yes.
Which,
And
go
Your
ahead.
Honor, if we may, Ms. Gainey has asked if we could waive the cost of supervision while she's on the PTI program. I don't believe she's employed at this point.
We have one in.
And her husband is working, but they are supporting the children. It's a financial hardship on Ms. Gainey, Your Honor.
All right, I'll waive cost of supervision based on the allegations that were made in the case and the specific term about supporting dependents.
Thank you, Your Honor.
All right, did you go over all of the terms of this agreement?
Yes, sir.
So in addition to the standard conditions of PTI, you're to support your dependents, pay your court costs, and agree to continue with and complete any classes, programs, counseling, or other requirements imposed upon you by Family First Network?
Yes, sir.
Are you still working with them?
Yes, sir.
Is there a pending case on that, or do you go to court for that issue as well?
No.
Okay, so it's just a non-judicial case.
It's through Carrie Nielsen.
Okay, but you,
Terry.
okay, but you don't have to go to court for it?
No.
Okay, I'm just trying to make sure if there's a DP case that's pending, doesn't sound like there is. All right, so you've gone over both of those agreements, you understood them and signed them?
Yes, sir.
All right, are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement that you've read? All right, and you understand by entering a plea, there won't be a trial of any kind?
Yes.
Do you understand you're giving up your trial rights on the first page of that plea and sentencing agreement that you read, understood, and signed?
Yes.
Okay, and do you understand that you're waiving any potential defenses that you may have?
Yes.
And also that, again, if you were to fail the PTI program, that you could be sentenced to 5 years in prison?
Yes.
All right. Obviously, I'm not saying that's what I would do. You know, your lawyer would have a chance to argue what I should do, and so would the state. Okay. Do you understand also if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the child abuse without great bodily harm?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. You're going to do the PTI program. Mr. Durrell, if you could hand that back to probation.
Yes, Your Honor.
Now that I've reviewed it, I did change that cost of supervision to the 0 as we discussed.
Thank you.
All right, and Ms. Gainey, make sure you speak with probation before you leave here this morning. You do have 30 days to appeal. There won't be a judgment and sentence, but any decision that's been made here by the court today. Good luck with the PTI program. Make sure you speak to probation on your way out.
Thank you, Your Honor.
Thank you.
I have Mr. James Stump next, Your Honor. Request a continuance for Mr. Stump, still reviewing discovery.
All right, looks like it's a new case from this year. It's 26 CF 18. I'll go ahead and put that on June 22nd, 9 o'clock.
Thank you, Your Honor. And last I have Mr. Roy Williams. Your Honor, depositions are scheduled for June 8th in Mr. Williams' case.
I've got that here. Okay, so are you asking for June 22nd?
Yes, Your Honor.
Okay. Any issue from the state?
No issue.
This case is getting a little older too. June 22nd, 9 o'clock.
Thank you, Your Honor.
All right. Anything else?
Your Honor, there is a open warrant for Mr. Williams. I believe when I called to confirm that, they told me it was a direct file. I've spoken with Mr. Sprouse. It's a contracting without a license. I believe it's all from the initial allegations. So I'm trying to see if we can confirm that it is, so that maybe we can get a stipulation on a bond, or if we can, if it is a direct file capias, if we can change it to no capias or something, so the man doesn't have to spend a night in jail for something that should have been addressed when the case first got started. I just want to let the court know I am working on trying to figure out what we can do with that warrant, see if we have to get them turned in, if we can avoid turning them in, to get it addressed that way.
The information that I would need to, I guess, determine is who the victim is on the direct.
Well, if it's a contracting without, it would be the state, would it not?
Well, it would be, we still put who kind of got scammed allegedly.
It's an MM case. I'm looking at the direct file, direct issue capias. It doesn't list anyone as a victim, just says basically the advertising. So I'm not,
Then that would be different than what we have.
Okay.
okay. Do y'all have that case number?
I don't, Your Honor.
Would you like it?
Yes, Your Honor, if I may.
I'm not sure what you'll be able to see, but it contains the case number 25MM2688.
Thank you very much, Your Honor. Yeah, I will continue working on that, see if it is from the same alleged facts and what we can do with it, if so.
It says on or about January 8th of 2025, and it's just, again, I don't think it has to do with contracting without a license, it's basically advertising as you.
Okay.
So,
Okay. Thank you, Your Honor. I
All right.
believe that's all I have.
all right, thank you, Mr. Drill, have a good day. All right, Ms. Merrifield, I guess I'm gonna jump back and forth between how y'all did this.
Morning, Your Honor.
I'm not gonna mention who put their name in the attorney column properly and who put their name in the defendant column, but
It's an interesting list. I'm going to try to get through this, Judge, but when I was looking up the clerk's site today, nothing worked. So, Bernie Merrifield on behalf of Timothy Bates, it's 25 CF 353. I believe he's on your list. He's been on again, off again. It looks like he just made it back to the list late Friday,
sorry, hold on just a second.
and they should all be listed under Flaherty.
Yeah, I'm just trying to get to the front of it. I have it on mine, which I printed mine on Thursday, I believe.
David Timmer,
Let's see.
Brittany Fowler,
All right. Tell me about Mr. Bates again, I'm sorry.
So in Mr. Bates' case, we have held depositions. I was waiting on Dr. McDonald's report. We did receive that, discussed that with ASA Leone. She did make an offer. We were provided some additional medical records. And in all candor to the court, Mr. Bates wasn't on my list for Monday. So I do have a meeting scheduled with him, but I was unable to do so before today. So I'm asking for one final continuance. I don't believe there would be an objection, so that we could get that additional reciprocal discovery. And Dr. McDonald does anticipate an updated report based on that information. It was something very significant.
Okay. State.
State has no objection, Your Honor. We would ask those be shared with us, though, as soon as possible. Absolutely. Get those reviewed. So I would anticipate this to be the last continuance, Judge. I don't foresee any.
I think that's what I said last time, so.
Yes, sir. Understood.
It does indicate ready for trial if this is not.
All right. So let's mark it as last continuance for Mr. Bates. It wasn't on my paper docket, so it must have just been added, even though it was on the docket on February 23rd, where it was set for today's date.
Yes, sir. And then also.
June
don't-
22nd, I'm sorry. Is he here or did you waive?
There is a waiver on file for
Okay,
Mr.
so I just want to
Bates.
make sure it's June 22nd as opposed to the 24th. June 22nd, 9 o'clock for Mr. Bates' last continuance.
And then another one that I'm not sure if it's on your list is Thomas Bennett and 25 CF 2008 waiver on file.
I do have that. I think it was just continued because depots are May 6th.
It was, Judge.
Okay.
So we did receive an order on that. The next case is Brianna Carrera. It's-
And I apologize if I didn't get to any of those orders until Friday. I was in a civil jury trial all week,
Understand, Judge.
so.
And then I have Brianna Carrera, it's 25 CF 2394 waiver on file. It's the first time up for my office.
Y'all just took over a couple weeks ago.
Yes, sir. We're still missing a little bit of discovery, did communicate that with the state. I'd like to see that discovery before scheduling depositions, so if we could set it for the 6/22 pretrial, I'm sure I'll receive that and be able to make some decisions.
State?
We'll make sure it gets out today, Your Honor.
Okay. June 22nd, 9 o'clock.
The next one is Charles Day in 25 CF 854. Like to leave this one set for docket day without. I do anticipate a resolution.
Weren't y'all looking at DPAs or PTI on those cases?
Yes, Judge.
Okay. I thought we resolved both of them. I guess I was
The
mistaken.
co-defendant case was resolved. Sometimes a simple resolution is a difficult one to be understood.
Very philosophical. All right, May 4th, 9 o'clock, please continue.
And then I have Joseph Felicia, 25 CF 530, waiver on file for Mr. Felicia. We had what we thought were our last round of depositions on April the 15th. During that time, another witness was disclosed that was also unknown by the state. So ASA Leone and I discussed taking the deposition of that witness. It would be important given the age of the child in this case. We are coordinating those depots. I just received that address late last week, so I'm asking for the 6/22 pretrial.
I saw that there was an amended discovery
Yes,
after
sir.
your depositions. Who disclosed a witness this late?
It was the witness, and this was also the case that at the original depositions, we learned of a witness, and then this particular witness was disclosed who provided another witness. Case has grown every time we sit down.
Okay. All right, hopefully this is the last time that happens. June 22nd, 9 o'clock. This case is now a year old. I understand the concerns, but let's make sure that we're making it a priority.
Then I have Nigel Fleming, 25 CF 2321. I did see an order continuing that case to the 6/22 docket.
I did sign that order, I believe, on Friday, June 22nd. You'll have depots coming up on June 10th.
We do.
So we'll see you back on that June 22nd date, 9 o'clock.
Then I have George Masterson, 26 CF 285. I'd like to leave this one set for docket day without. I anticipate a resolution.
That's correct, Your Honor.
There's a waiver on file.
All right. May 4th, plea or continuance, 9 o'clock. First time up.
Then I have James Reese, 25 CF 2317, waiver on file. We did conclude our depositions, and I'm asking to set this one for docket day without. I do anticipate a resolution on that one as well.
All right, State.
There will be a resolution on or before that day.
Okay. May 4th, plea or continuance.
And then the last one that I should have, Judge, is Sean Stout, 25 CF 1088. We did complete depositions. This is ASA Bosshaus case. I'm asking to continue this to the June 22nd. Anticipate it would be the last time. Ms. Bossow and I have discussed a potential resolution, and we are waiting on the Dr. McDonald report. I did speak with Dr. McDonald. She is aware of the court date and trying to get that prepared as quickly as possible.
That's accurate, Your Honor.
All right, last continuance, June 22nd, 9 o'clock.
And that should be everything on my list, Judge.
That's the last one I have.
Thank you.
All right, Mr. Switek.
Morning, Your Honor.
Good morning.
I'm Switek for Dion Olszewski,
Olszewski, okay.
25 CF 1662.
All right, what are we doing with Mr. Olszewski?
We are set for Thursday for a competency determination at 2 o'clock.
It's this Thursday?
Yes, sir.
What's that date? 30th. Have y'all sent all the reports in? Are they filed?
Yes, sir.
I just want to make sure I read them before then. All right, I see the Cornerstone is filed. Oh, here's just the other one.
With some related cases, including a guardianship case that have reports.
Charlie Gold.
Who are the two reports by? I just want to, again, make sure I've got them both so I can read them in advance of Thursday's hearing. Because one of them has an MM case number on it, and the other one I can't see. It's redacted. So, do you have both reports, Mr. Switek?
I believe I've got all of the reports.
All of the reports. Could you make sure just to send a courtesy copy to my office so I can make sure to read them before Thursday?
Yes, sir.
I'm just worried that I'll try to pull them up and they'll be redacted, or I can't open them and then I won't have read them all, so. All right, thank you, sir, I appreciate that. We'll see you on April 30th, and then we'll make a decision on your next pretrial at that point, if needed. All right, thank you, Mr. Switek. Next, I have Mr. Garrett. I didn't see him. Mr. Cotton?
Good morning, Your Honor.
Morning.
Your Honor, I'm also going to be handling some cases for Michael Gates and Cassie Reed.
Okay. Are you starting with yours?
Judge, if it,
I just want to know which page I'm flipping to.
I'll start with whichever page you're on, Judge.
Well, I flipped to the front, so that would be you.
That's me.
Alphabetically.
We'll handle mine first, Your Honor.
Okay.
The first case I have is Damon Richard Becknell, case number 20 CF 10. Your Honor, this case currently has a motion for reconsideration pending. It's already been set on your 5-7 docket.
I saw that. Are there transcripts from any initial hearings? It's a motion to reconsider, but obviously I didn't consider it in the first place. It wasn't my case when that order was done.
That's right, Judge. I believe I have transcripts of that I can provide.
If you could, that might make it easier for me to catch up to speed.
When I get to my office, let me double check what I have. If not, we'd be willing to get those transcripts if we have to move it technically, but.
I can probably watch the court smart of it.
Yeah.
I just want to know if they're there. If you have them transcribed, if you could send them to me. If you don't,
because
just.
I believe I quoted from the transcript.
Okay, so you probably have them.
I probably.
All right, so if you could send those over to me if you do have them. If not, just tell us you don't have them, but if you quoted from them, I would assume that you do. Just because it's a.
I'm not looking at it, but I think I did, Judge.
It's from a while back, and again, I wasn't part of that
Yes,
hearing,
sir.
so I want to make sure I'm seeing everything.
Yes, sir. That, depending upon the court's ruling on that, I do have some other motions, I think 2 others, maybe 3 others pending but after the court's last ruling, I needed to amend those. This one didn't take an amendment, so I went ahead and got it set for the court. We may or may not need to move forward, but I just went ahead and set the one, Ms. Boston and I set the one that didn't need an amendment based on the court's last ruling. So,
Okay. I guess this shouldn't need to be said, but I'm going to say it. This case is the oldest case on my docket,
Yes.
short of something that's come back on appeal or something that's been in capia status for years. It needs to get resolved.
Yes.
So if there's future motions that need to be filed, file them. If they need to be set for hearing, set them for hearing. But I don't want this to be one hearing every month. And, for the next 6 months, I'd like to hear them all.
I understand, Judge, and
Okay.
I will get all of those updated and filed within this cycle.
Okay. All right, anything from the state? June 22nd, I'd like for all motions to be done, at least filed and then set for hearing by that date.
Was that, I'm sorry, Judge.
June 22nd.
Yes, sir, thank you. Your Honor, the next case I have is Michael Pakacek, case number 24-1486. Your Honor, the status on that is as the court's aware, there is another witness. We have reached out to him. He touched base with our office on Friday.
Is this the Bay County witness?
It is. he touched base with our office on Friday advising he'd been, I think he was out on training. But he is supposed to be touching base, or we are touching base with him today or tomorrow based on the coordination with my paralegal, that he's going to transport the evidence over to Okaloosa so that my expert can view it. We are also working on, obviously I want my expert to be able to view it, to be able to prepare for the deposition. Ms. Bosso and I have spoken a little bit on that because I believe he may have a medical procedure, so we're trying to get.
Docket after a certain date, so we're trying to get the deposition done before that as well.
So
Do our best, since it's been pending for quite some time. I think we had the motion to dismiss that particular count because of this issue, and that's when y'all found out about the Bay County.
Yes, sir. So obviously, we're coordinating, trying to get everything worked out and set on that, Judge. Obviously, I know the state and I have both provided updated information on the last motion before the court, which was a plethora of information by both parties. I'm sure the court has not had.
All the memorandums came in at 3:27 and 4:35 on Friday afternoon.
Yes, sir. So I'm sure it'll take.
I know y'all had asked for an extension to that date. I'm not concerned about that, but obviously I haven't had a chance to read it.
No, sir.
Since they just came in late Friday afternoon.
Yes, sir.
All right.
So for the reasons set forth above, we need one more continuance to be able to hopefully wrap this up. I would imagine that the deposition, if I have grounds still for my motion to dismiss that count, it will be reset. And within the same parameters of the June 22nd, we talked about in Mr. Beckmill's case.
Okay. All right, anything from the
No
state?
objection, Your Honor.
All right, June 22nd at 9 o'clock. Again, like the other case, let's make sure that if there's any future motions need to be filed, they're filed and set for hearing before that date.
Yes, sir.
And when I say set before that date, I mean scheduled, if they have to
Get 'em
occur
on.
after, get them on the calendar before that date, so we know where we're going the next time we're here.
That was going to be my question. Thank you.
And I'll do my best to get you an order on the suppression motion now that I have the supplemental memoranda.
Yes, sir.
I just, again, haven't had a chance to review them yet, but I saw that they were filed.
Yes, sir. That's all I have before the court. If I could handle a couple of cases from Mike Gates.
Okay, let me get to Mr. Gates. So that was June 22nd, 9 o'clock for Pekachik.
First one, I believe, is going to be maybe an Elizabeth, I'm sorry, Paula Haberlin, Haberlin.
Have you
Your Honor,
seen Ms.
that's-
Haberlin, or is there a waiver?
I believe there's a waiver, Judge.
Okay.
Case number 26CF330. Your Honor, that's Miscellaneous case. Mr. Gates advised that depositions are currently set for May 6th, 2026. There is a pending motion for a CPT order. I believe the state has no objection to that.
That was my question. I've got the order in front of me where I put a tag on it for my assistant to reach out to y'all on, this was just from Friday when I saw it, to see if you had any objection to the order as it was.
There is no objection to that, Your Honor.
Okay. Again, I reviewed it on Friday, and since there's no objection, I've just signed it.
Okay.
But for future reference, that's for anyone, if they're on those CPT record, just if you can make sure that, the state has had a chance to see the order, that way I know, because there's usually an issue with, is this the proper language that everyone needs? So that's why I usually have my assistant reach out to the state if I don't see that in the motion or in the order somewhere.
Yes, sir.
All right, thank you.
The next case, that
So I'm sorry, that's going to be June 22nd, 9 o'clock. It's the first time up, and I've signed the order that we've just discussed.
Thank you, Your Honor. Your Honor, the next case is going to be Elizabeth Harlan, Harlan. That's case number 25CF1718. I believe that may be a DPA, and with Ms. Flowers, and we're going to leave that set for docket day to try to resolve.
That's correct.
Okay, that was the note I had from last time, so May 4th, plea or continuance, 9 o'clock, but possible DPA.
Your Honor, that's the last case for Mr. Gates. I have one more case for Ms. Cassie Reed.
Okay, let me get there.
Yes, sir. I don't know if that's going to be under C or S. It's a hyphenated last name, Coachman Seiler.
Oh, well, if it's all, my docket is based on lawyer's last name.
Okay.
When you said CRR, I don't think we'd have another Cassie.
Got it.
Oh, there it is. All right. Corey Coachman Seiler, 25CF2250.
Yes, sir. Ms. Reed has asked me to leave that set for a plea on docket day.
All right, 5/4, 9 o'clock for a plea.
Your Honor, I believe that's all I have on your docket.
Okay, and everyone else at
And
your
everyone
office?
else.
Okay.
Thank you, Judge.
Thank you, Mr. Cotton. Have a good day. Mr. Hardy?
Ryan Hardy, on behalf of Roger Bradshaw, Your Honor. We're going to ask to set this for the June docket.
You don't sound great, Mr. Hardy.
I am over it, thankfully, but I missed the entire week last week with flu B,
Well, if you ask to approach, I'm going to say no, just to be careful.
including canceling 2 final hearings, and Your Honor knows how my schedule is. It was awful. One of the reasons I need.
In this division, I don't get to see you as much as I saw in the other division, Mr. Hardy.
And one of the reasons I need this for June is, Your Honor, I just don't have it available in May, to be honest with you, and I could go ahead and block this off and be ready if needed for June. Mr. Bradshaw is present.
Okay, let me just get to it here. All right, State, have any issues with that?
I have no issue, Judge.
All right, so the June 22nd date,
Thank you, Your Honor.
9 o'clock. Mr. Bradshaw, we'll see you back on that date.
Thank you, Your Honor, that's all
All
I
right,
have.
thank you, Mr. Hardy. All right. Mr. Cobb? Saw you in here earlier. I called you when you left, and
Yeah,
we're back.
I knew I shouldn't have snuck out to do something. I should have stuck around. I have 2 cases on your docket this morning, Judge. The first one is State versus Veronica Williams, 2025 CF 2335. I'm going to be asking for continuance to June. I got the discovery March 16th. I just finished reviewing the discovery, and I'm going to want to take 3 depositions, and I'm going to tell the court I will contact Ms. Marino this afternoon and get those dates scheduled, but I am asking for a June continuance.
All right.
No objection.
All right, June 22nd at 9 o'clock. We'll see you back on that date.
And then the other case I have, Judge, is State of Florida versus James Harlan Cardell. He was out of custody, but he got arrested, I believe, 2 days ago
Okay.
on a petty theft charge.
Did y'all have him as that, Matt? Let me just take a look. Card. That looks like him. Arrested on a petty theft charge. Yep,
I believe right after I spoke to him on the phone.
Friday.
Yes, sir. But last week after reviewing all the discovery, I contacted both the former attorneys, Mr. Williams and Mr. Kleins, about the depositions. Mr. Williams' office emailed me 3 audio recordings of the depositions that he took in the case when he had it. I received those over the weekend. I'm going to listen to them. There are still 2 remaining people I'd like to depose. Mr. Kleins had scheduled them for depos, but then I got appointed before those depositions could go through. I know this is an older case than the other case that I have, but I am going to be asking for a June date to finish that. It'll be ready to go by then for sure, if we have to.
That's without objection. I've been copied on all of Mr. Cobb's emails to the previous counsel that heard.
All right, I see that now. All right, for the reasons stated in the fact there's a new case, he hasn't, well, it looks like it's gonna be an MM case probably. So it may be a felony. All right, June 22nd, 9 o'clock. Well, let's say June 24th at 9 o'clock since he's in custody.
Yes, sir. And I checked on, I just want to make sure that's the 2 I had on the docket. I went online, but the website was down. Do I have any additional ones on the docket?
I have Edith Rolandi.
All right, I know that I saw her. Ms. Rolandi, you're here.
Right.
So the issue is, I'm granting your order, or your motion to withdraw. We discussed this last time, but we have to go through a Feretta inquiry, so I didn't need to know if I'm appointing someone else at that point. So we'll address that with Ms. Rolandi later, but you're going to be off the case.
Thank you,
All right.
Judge.
All right,
Those are the
thank-
2. Can I be excused?
Yes, sir.
Okay.
All right, Mr. Garrett, I think I called you earlier and you must have stepped out.
Good morning, Your Honor.
Morning.
Your Honor, there are waivers on file for my clients today. First, Chris Garrett on behalf of Jason Brown, 25 CF 722. We are setting up a deposition of the juvenile witness.
Victim, we talked about that last time. Why is it not set?
I don't have a good reason for you, Your Honor. I've been trying to get it set. I think we switched prosecutors at one point. We're trying to get that done absolutely as soon as possible.
All right. State?
State is ready. I've got a pretty free schedule, so.
Okay.
whenever.
Well, I'll see you back on May 4th at 9 o'clock to see that it's set.
Yes, Your Honor.
All right. It's an April of 25 case. I'd like to get it moving if it's over a year old.
I understand.
All right.
Then Chris Garrett on behalf of Vincent Durden, 25 CF 1998. We've not received the FDLE analysis for this case. I just spoke with that about it with the state. We'd ask for a continuance to the pretrial.
Status, Mr. Sheik?
The state does not have the FDLE analysis, so we're gonna look into it and make sure that we can get that and send it to the defense as soon as possible, Your Honor.
All right. 6:22, 9 o'clock.
Then Chris Garrett on behalf of Victoria Hartley, 25 CF 574. Your Honor, we received an amended offer from the state this morning. However, it is still a prison offer. We'd ask for a continuance to June 22nd, and I anticipate that being a final continuance.
No objections.
June 22nd, 9 o'clock, last continuance.
Yes, sir.
Is there anything else that has to be done in the case? I know you all had depots last month.
Yeah, I don't believe there's anything else that needs to be done, Your Honor.
Okay. All right, so that'll be last continuance.
Then Chris Garrett on behalf of Sidney Jenkins, 26 CF 104. This is a recent case. I know the state.
First time up.
Yes, Your Honor. We'd ask for a continuance to June 22nd.
June 22nd, 9 o'clock.
And then finally, Chris Garrett on behalf of Timothy Scarborough, 25 CF 2295. My understanding is that there's a very good chance this case is going to be going back down to misdemeanor court. We'd ask for either June 22nd or leaving it set for May 4th for status, which.
All right, what's the state's status on that one? Is it going back to Scarborough?
We were unable to get, it's gonna have to sit, I'm gonna send it down to county court because we just can't get the second certified conviction, so I just
Okay.
have to get that done.
All right, is that gonna get done this week?
Yes.
Okay, so let's just put it on May 4th to see if it resolves itself as far as the transfer.
Thank you.
All right, thank you, Mr. Gary.
Thank you, Your Honor. Have a good day.
You too. All right, I'm not sure who was here next. Mr. Powell, I think you only got one, right?
Yes, we
Why don't we call you up?
Sorry, I didn't get on the list.
There's Jennifer Money.
I asked Mr. Stewart if he was covering for you, because he covered for all the, everyone else, but he said he wasn't aware of it. He tried to, still try to cover for us. I'm sure he'll be here.
Thank you, Your Honor.
All right, go ahead, Mr. Powell. This is Austin Jordan, 25 CF 2459.
Yes, sir, Your Honor. And last time we were planning on filing a motion for post-conviction relief under case number 216 CT 0989. It's an old case. That's where he was confused on the felony conviction. So we were trying to get this motion set.
Has it been filed?
Yes, sir. It was filed on April 13th. It was pretty extensive because we had to do a lot of research to get back all the facts of the 216 case. So it would be dispositive of this case, and I think it's pretty meritorious. But I think Serena had tried to set it, but she was trying to set it under the present case, so.
Okay.
I apologize for that.
I hadn't seen the motion, so.
I have a copy if you want to.
I see it now. It was just
Yes,
filed on
sir.
the
I'm
13th,
sorry.
but
Yeah, it's I can briefly tell you the gist of it. And then I was I'd sent a copy to the state to discuss with them on conferring.
Which email did you send it to, Mr. Powell? Email did you send it to?
I sent it to Ariana.
Okay.
Sorry.
I have not seen this motion. It's news to me.
Bottom line is, Judge, is that when he violated his probation, it was based on a arrest for driving while license suspended. No one knew that, and we found out that his license was never suspended. He entered a plea based on his attorney's advice for violation of probation, based on a case that shouldn't have been charged with. The state now processed the case on June 7th of 2019.
So is it it's ineffective assistance at counsel that's been filed how many years after the fact?
Yeah, based on newly discovered evidence. It's what part of my motion.
Okay, I'll read it, but make sure it gets,
Okay.
I just hadn't seen it, obviously, that
Did a
case is
lot of
not on my
research
docket.
On timeliness, so.
Okay.
So I guess we'll need to set that motion. We can leave this, was the May 4th docket day? Or a plea, or if the state.
Well, I mean, we're not gonna get it set before then.
Yes, sir. It's only second time up, but I know we like to try to keep them moving without.
Let's put it on the June 22nd date, but let's get that 3850 filed beforehand.
Yes, sir.
All right,
Thank you, Your Honor.
thank you.
That's all I had.
All right, thank you, Mr. Powell. All right, anyone else? Did y'all arm wrestle, draw straws? What are we doing? Mr. Nopes?
Judge, I've got one case for myself and one case for Jeremy Keach. My case is LaShawn Briggs. Judge, I believe it's the first time up, 26 CF 0233. I was just going to ask to continue it to the June 22nd.
All right, it's first time up, June 22nd, 9 o'clock.
Judge, and Mr. Keach.
What about Zachary Heineke? I have that for you.
It's Noel Prost.
It's not Prost? Okay.
Yes.
No one told me.
Mr. Keach has Zachary Mason, 26 CF 312. First time up. And
Hold on a second. I also have Colby Sanders for you.
Judge, he's incarcerated.
He's incarcerated, okay. So we'll just see him on Wednesday, 4/29. All right. Just want to make sure it's clear on my end.
Sometimes these dockets don't make sense, but anyway.
I'm not going to respond to that.
I'd laid it out there you could get a free swing at it. I mean, anyway. They're aggravating. Jeremy Keach, Zachary Mason, 26 CF 312. Judge, he's asking to continue his first time up.
It looks like a first time up. Any objection from the state? All right. 6:22 at 9 o'clock, if you could tell Mr. Keach about that. All right, anything else, Mr. Nopes?
I think that's all I've got.
All right.
Have a good day.
Mr. Williams is jumping up. All right, Charles Williams.
And the case is coincidentally State of Florida versus Byron Williams.
Okay.
He's going to approach and join me here at the podium. It's 25 CF 2336, Your Honor. First time up.
This is the co-defendant of Mr. Cobb's.
Correct. And there's also.
And then there's the other case that the PD and RCC and everyone else has.
I've got some checking around to do, but I think that June 22nd date, we should have some answers.
Okay.
Without objection.
All right, it's on November, so let's get a move on. If there's anything else that needs to be done, I know there's the other case that's related.
Don't anticipate depositions or anything like that, so if there is anything, I'm sure Mr. Sprouse and I can work it out by then.
That's correct. The earlier case is the driver.
Of course. All right, June 22nd, 9 o'clock.
Yes, sir. And I believe that's all I have, Your Honor. I had one on the docket earlier.
McLaughlin.
But he has since been
Arrested.
picked up. I believe he's been moved to the Wednesday.
So he'll be on Wednesday, the 29th. I think, is that the one, Mr. Sheik, we just had the pretrial detention on Thursday?
What was the name again, Your Honor?
McLaughlin?
It was, yes.
Yeah.
Okay.
Oh, yes.
So his bond was revoked in this case based on the new case we had the pretrial detention on. State didn't seek pretrial detention mainly because his bond was revoked in this case, so I did set a bond on the new case. If y'all want to look into that one to see if that's something I'll assign to you so he has one lawyer, but.
Yeah, I'm not sure if I'm going to be appointed on the case. I know that it takes a little bit of time to work through the system, but I When did the pretrial detention hearing set?
It was set last week.
I mean, what time?
Oh.
Thursday?
No, it was last week, Thursday at
Oh, so
12:30.
You've already had it?
Yes.
Yes,
A bond was
you weren't
given in
assigned
that
to it
case.
yet because,
I misunderstood. I was just gonna say, I know I'm gonna be here Thursday,
no,
and, okay.
no, it was this past Thursday. It was only about a 5-minute hearing because the state didn't pursue it based on what I've said already.
And from speaking with Mr. Williams, I believe that's just going through the process to probably eventually get to you.
Just Mr. Williams or
This-
the
No, no,
Mr.?
sorry, yes.
The other Mr.
Right
Williams.
now, Mr. Kleins is appointed, so it's going through.
Okay, all right. Just trying to make sure the record's clear because we're referring to two different Williams.
We've had that, the other Mr. Williams and I have had those problems before.
Yeah. All right, so that one, we'll see you on Wednesday for that one, 4/29.
And I believe that's all I had on your document.
All right, thank you, Mr. Williams.
Thank you, sir.
All right, Ms. Dudley, Mr. Catalinic, Mr. Rare.
Go ahead.
All right, Ms. Dudley.
Your Honor, first one has Charles Blanchard, 25 CF 214. Your Honor, we're still waiting there was the case officer who's on workers' comp, so we can't get a deposition. The state's waiting for him to let them know when he's gonna be back at work.
I have spoken with that officer. He doesn't have an update of when he's coming back from FMLA. It was pretty serious procedure that he had going on.
Okay. All right, June 22nd, 9 o'clock.
And next I have is Roger Daniels in 25 CF 2015. We're still waiting on discovery. We got initial.
Out-of-county reports.
Yeah, we don't really have anything.
Whose case is this? Who has Roger Daniels from the state?
Mr. Sprouse.
That's me, sorry, Judge.
Okay.
I spoke with the AUSA,
Okay.
and we're not able to get the evidence that we need for the case. The indictment should be coming soon, but I have nothing else to add. It's an older case.
Yeah.
But I've spoke with the case officer that's local, and then the AUSA that's in Pensacola.
All right, so you think the feds are taking it?
They're 100% gonna take it, is what I've been told.
All right, what would you like to do, given that, Ms. Dudley? Put on June 22nd to see if that happens?
Yes, sir.
All right, let's make sure that happens. I know you have nothing to do with that say-so, Mr. Sprouse, or anyone from your office, but
They have my number now, so they'll reach out.
all right, who else do you have, Ms. Dudley?
I have Christopher Green, 25 CF 1715. We filed a motion to dismiss, based on
Friday.
depositions. Yes, sir.
So it hasn't been set yet?
It hasn't been set yet.
All right. 6:22 at 9 o'clock. Let's make sure that's set before then.
Yes, sir. Kevin Johnson, that's the one that came back on appeal, 23 CF 210. Based on the transcripts, I got a motion to dismiss the one count, based on the.
So this is the one, let me make sure I remember. The court previously, Judge Gunter had granted your motion to
Correct.
suppress, and that was reversed.
Correct.
So now you're filing a motion to dismiss, which was
Yes.
filed.
Yes, Your
So
Honor.
it's-
If we can get to 622, and we'll get that scheduled hopefully the same time as Mr. Green.
Okay. It's gonna be a
Then-
big afternoon for you probably then. Well, just, the reason I say that is
Floors, so they're not.
every once in a while, we get a lot of hearings that actually go. That's why we were here till 10 o'clock, the last miscellaneous date. So just make sure if you're scheduling two,
Yes, sir.
everyone's kind of looking at the docket as far as what's getting set on those days. So we don't end up in a situation where y'all are here till, I think it was only 9:48, to be honest.
Yes, Your Honor. The next one I was Logan Killebrew in 24 CF 1565. Can we leave him set this Thursday for a plea?
This Thursday?
Yes, Your Honor. He lives, in Central Florida, or next Thursday, either one. I have depots Monday in Definiak, so.
Do you have anything on Thursday? Just so I can put, looks like you've got.
Yeah, I have a motion on that day.
Looks like you've
Motion
got Bachman in the morning?
Yeah, motion to return property. It should just be a plea till time served.
Okay. Any objection to putting him Thursday morning?
No objection.
All right, let's put him Thursday morning, that's April 30th at 9 o'clock for purposes of a plea.
Yes, Your Honor, thank you. Your Honor, next I have is Cameron Moffitt at 25 CF 1508. You know, as for continuance, we've taken some depots, we have to reschedule a few of the other ones.
Are they, what day are they scheduled?
We just had it, we haven't got a new date yet.
Oh, you just had them?
Yeah, we just had them, Your Honor, sorry.
Okay.
Friday, I believe.
Okay, all right, some depots. All right, 6:22, 9 o'clock.
Yeah, the next I have is Adam Phillips in 25 CF 290. I believe he has another case. It is hit him on list though. We've taken some depositions, we have to reschedule, some that did not appear.
The victim did not appear.
Correct.
Has the state had any contact?
We had contact that day. I was on the phone with her. She said she forgot.
He also has 292, Your Honor. Oh, I would just ask for continuance.
You said he has another case?
Yes, Your Honor.
Is that, that's not on this
25
docket, is it?
It should be. They were on the docket.
All I have is 290.
I think they were on the docket last cycle together, if I'm correct.
Oh, I don't doubt that.
So I think it's 290
hold on
and
a second.
292. It's two cases.
The last thing that's in the 292 cases from October to put him back on pretrial supervision, but he doesn't set on this one.
Okay, can we set up with this one on for the next docket?
All right, it'll be June 22nd, 9 o'clock, but that's also at his other case, which is 25 CF 292. Yes. Okay. Yes, you can go ahead and grab the minute sheets.
Alright. The next one I have is Connor Prince, and.
Give me just a second so we can.
Gotcha.
You're okay. I just want to make sure that Clark has the new sheets. That way I'm not handwriting everything.
Mm-hmm.
All right, Connor Prince.
Your Honor, this is the one I've been trying to set depots with the co-defendant / victim. They're victim in each other's cases, but I don't know, it's weird. This is the pretrial hearing we had. The co-defendant now has a new attorney. He got charged with another case.
I'm familiar.
Yeah, so I would ask for continuance. I've talked to Scott Kleins. He hasn't even looked at the discovery yet on the co-defendant.
I think he just got that case,
Yes,
right,
he
Mr.
did.
Klein? That's the McQueen case.
Mr. McQueen's other case, the older one, yes, I had just,
So do you have his older case now?
yes, so what happened was Mr. McQueen has the newest case. I did the pretrial detention hearing on that, and then the next day, Mr. Tony was hired by him on that case. So I have the older case still, which we have already filed a motion to continue. The court's already granted that motion. But I was talking with Ms. Dudley, and this is something we hopefully can get up to speed and get it squared away, ready to go relatively quick.
This is the case where they're basically charged with shooting at each other.
Correct. I think in 2024, but the arrest date didn't happen until a year later for some.
Yeah, the warrant came out a year later. This is when we had the pretrial detention.
No, I'm
yeah.
very
So I told
familiar
Mr.
with
Mr.
the
Kleins would call me,
situation now.
And I am working on getting a transcript of that testimony based on what was said during that hearing.
The pretrial detention hearing, okay. All right, 6:20. 6/22, he's out of custody, right?
Yes, Your Honor.
Okay.
Oh, okay.
Your client is?
Yeah, I was gonna say, no, Mr. McQueen's in jail. Yes.
My client is out, Your Honor.
All right. 6/22, 9 o'clock.
Yes, Your Honor. Last one I have is George Scott in 24 CF 2605. We have depots scheduled, I believe it's June 10th.
This was the last continuance. Why are depots still going on in a case that's from November of '24?
Well, I got it after his bond got revoked, and they hadn't been, so I did schedule them. We thought we had a deal, and based on victims' communication with the state, we can't do that, so I have to do the depositions.
All right, June 22nd, 9 o'clock, I won't entertain another continuance.
Yes, Your Honor. I think that's all I have. I couldn't check this morning, but I had checked last week.
That's all I have for you, Mr. Lee.
Thank you, Your Honor.
All right, Mr. Rare.
Morning, Your Honor. For the record, David Rare and Judge, for Mr. Lupella and I, all our cases are together under his names because they're filed as co-counsel.
I'm flipping there, I'm just not there yet. Go ahead, I'm there.
The first case I should have on the docket, Your Honor, is Travis Bice, B-I-S-E. Speaking with the state, I think we have an agreement reached out. We're just going to figure out some restitution numbers and get those solidified. If we can continue this one cycle, I'm hoping we can get this dropped off the docket before then.
It's a 2024 case number. It says arrest date was from February of '26.
Yeah, he was just recently picked up on the warrant, and then I think, retained extremely recently.
Okay.
Yes, Your Honor.
Oh, was it a direct file? That's why I got a case number?
Yes, Your
All right. I'm like, there's something there. I just can't see it from what the
I know,
docket
well,
says.
I did
Okay.
double take when I saw the case
All
number
right.
too.
June 22nd
Thank you, Judge.
at 9 o'clock. So it's basically the first time up. It just has an old case number.
Right, I'm just letting the court know what we're working on.
I got it. I appreciate it, Mr. Guerrero. Just, that one kind of threw me for a loop. All right, next one.
Next I have Judges Stephen Gardenier. We finished the first round of depositions for Mr. Gardenier, missing a couple people, but I spoke with the state about a possible resolution. I was waiting on them to kind of follow back up with me. I'm not sure if they had that chance. If you want to set it for docket day without maybe, or?
We could do docket day without, and then that's to make sure that we get, at the very least, get the witnesses all added. While doing depots, we discovered more witnesses that need to be included, Your Honor, so we're gonna add those, get that going forward, but we might be able to resolve it.
Okay, perfect.
All right, May 4th, 9 o'clock. Clear continue?
Clear continue, Judge. It'll either be a resolution or maybe more depots, but hopefully we'll get it resolved.
But y'all just did a bunch of depots a couple weeks ago.
Yeah, we had one show up, but we'll see. Like I said, we might be able to get it resolved. But the next judge I have, Judge, is Marcus Hamilton, and I'm not sure if that's still on the docket. That was supposed to be dismissed.
Ms. Leone has those notes, but we'll follow up on that. So we just leave it for status, Your Honor, on docket day?
Let me know when you're ready.
All right, 5-4 for status.
The next case I've got, Your Honor, is Joshua Lemke. I've gotten through the initial discovery. I've gone to the sheriff's office and reviewed some digital evidence there. I'm ready at this point to move forward with depositions. I'm going to try to follow up with the state sometime in the next week or two, maybe discuss possible resolutions, and if not, move forward with the depots, get those set. But for today, I'd ask for our one cycle continuance.
Without objection, Your Honor, just shoot me some dates, we'll fit you in.
Perfect.
All right, June 22nd at 9 o'clock. Let's make sure those depots are set. Did you also have James Graham?
I didn't have that on my list, Judge.
On mine, so. Oh, it says PTI to be filed. Yeah. Looks like the PTI was filed. Right, so let's just make sure on that. PTI agreement was filed on James Graham in 25 CF 2496. Unfortunately, it's coming up as correspondence letter from probation. So-
Okay. Do we need to add it to May 4th?
I don't think we need it at all. 'Cause
Oh, okay.
The PTI agreement's been filed, it's just
Right.
mistitled.
Oh, okay.
So it's probably why it's still on the docket. All right. PTI was filed back on March 2nd. All right, what else did you have?
Last I should have is Sigrid Wasden with a W. This one, Judge, we're trying to work on this one. If we can set that plea continue for May 4th, we're going to see if we can bring it in for an early landing, or at least a quicker landing.
Yeah, I think you're past quick. All right.
That's why I corrected.
All right, May 4th, 9 o'clock, plea or continue.
All right, but Judge, and I think that's all I've got on my list.
That's all I have.
Have a good day.
All right, Mr. Catalinic.
Thank you, Judge.
Thank you, Mr. Rare.
The first case that I have, Your Honor, good morning, is Mr. Gregory James Spencer, case number 26 CF 260, sir. We have deposition set next month, Your Honor. I think it's the first time up. It should be resolved within the next cycle.
All right, State. Any issues with that? Oh, is it your case now? Okay. I think it's a different case every time, or a different attorney every time. All right, June 22nd, 9 o'clock
Thank you, Judge.
for
And
depots.
the last case is Peter White, WHITE, sir, 25 CF 2037. Last continuance, Judge, I believe this is the second continuance I'm asking for on this case. We have deposition set next month. It's similar, it's another battery case, basically. It shouldn't take that much time.
Let's see. What are the depots set?
Judge, I don't have a date, but there's sometime next month. I apologize about
Okay.
that.
Depots in May.
Yes, sir.
June 22nd, 9 o'clock. Let's bring it in for a landing that time.
Yes, sir, I
Hopefully.
appreciate it. That's all I have, Judge.
All right, thank you.
Thank you.
Mr. Tony?
Good morning, Your Honor. Your Honor, the first matter I have, State of Florida versus Kevin McKinley, and that's 2026 CF 333. Your Honor, may we approach on
Hold on,
that?
just, who is that again?
Kevin McKinley. Should be two cases, but I only saw one on the docket.
Kevin McKinney, okay. Why is that not showing up? Oh, you're just going out of order. All right, you can approach this. All right, so Mr. McKinney, it's 26 CF 333, will go to June 22nd at 9 o'clock. Also, he's got one set for Friday, or for Wednesday, but he's no longer in custody. That's 24 CF 1580. That'll also go to June 22nd. So we can take that off of Wednesday.
The next matter, Your Honor, is State of Florida versus Jarvis Darcy, and that's 2025 CF.
Darcy.
1330.
Okay. Go ahead, Mr. Tony.
You know, we had that set for depositions, but I had a little technical difficulty, so we're gonna have to reschedule that one.
No objection.
You try and do them by Zoom or something?
No, worse, my assistant didn't.
Okay, I gotcha. All right, let's get those, are they reset yet?
No.
All right, get those reset and done by June 22nd. This is a July case, so.
The next is State of Florida versus Donald Stewart Hinton, and that's 25 CF 1283. Leave that set for a plea or continuance, Your Honor. I think we've had conversations about it. I thought we had this case resolved, but apparently there was an issue with regards to the alleged victim not wanting to agree with the settlement. So I think we just got to talk to the state about that and see can we get that resolved.
All right, May 4th, 9 o'clock, plea or continue.
May 4th?
Yes, that Monday.
The next case is State of Florida versus Alexander Todd Moore, 2025 CF 1991. You know, we had this set for a deposition, but the alleged victim did not appear.
They'd had any contact?
I have not had any contact with.
Are you gonna try and reset the depot then, Mr. Tony?
Now, I guess we don't have a choice unless they want to know process.
Well, I've tried to contact, have not been able to.
Why don't y'all have a discussion about what you want to do next, but this case is getting a little bit old. June 22nd, 9 o'clock.
The next case, Your Honor, is State of Florida versus Chelsea Free, 25 CF 1706. Once again, Your Honor, we had this matter set for deposition, but the alleged victim did not appear.
Contact?
We have had contact with the alleged victim.
Any reason why there was a failure to appear?
I'm not sure if they were properly served or not, because this person is very invested in the case.
They were served by process server.
So it was posted on the door. All right, June 22nd, let's make sure that gets reset and done by then.
Next, Your Honor, I have State of Florida versus Amberlynn McGovern. Mrs. McGovern is here. That's 2025 CF 1014. Pursuant to negotiation with the State Attorney's Office, Your Honor, Mrs. McGovern withdraws her formal plea of not guilty and pleads no contest to battery, first-degree misdemeanor. Adjudication will be withheld, and the defendant agrees to have no violent contact with the victim. The defendant agrees to complete Veterans Intervention Program. The defendant agrees to complete 50 hours of community service work, or she can buy it out by making a donation to the Domestic Violence Nonprofit Organization. She agrees to court costs and credit for any time served. She will receive 12 months of probation, and she must have a mental health evaluation. May I approach, Your Honor?
Yes. Just to make sure I'm clear, so this was a plea to PTI and then it came back?
That's correct.
All right. Just wonder why I have a misdemeanor on my docket that hasn't pled, so just trying to catch up. All right, Ms. McGovern, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name and date of birth, please?
Amberlynn McGovern, 10399.
All right, and Ms. McGovern, you're here in 25 CF 1014, where you're currently charged with battery, touch, or strike, a first-degree misdemeanor. Do you understand that?
Yes.
All right. I've been handed a plea and sentencing agreement that would call for you to plead no contest. In return, to be a withhold of adjudication on that count. You agree to have no violent contact with the victim. Batterers Intervention Program, which is a 26-week counseling program. Are you aware of that?
Yes.
You're to do 50 hours of community service, or you can buy that up by making a donation at the statutory rate to a domestic violence nonprofit organization. Court costs would be... Was it domestic?
Yes, Your Honor.
Yes, okay.
I think he's already paid the court costs.
12 months probation, and then there's also a mental health evaluation, any recommended treatment. Did you understand all those terms, Ms. McGovern?
Yes.
Did you go over this plea and sentencing agreement with your lawyer?
Yes.
Did you understand it all?
Yes.
Do you need any more time to discuss it with him?
No.
All right, and are you satisfied with his advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement that I've just read?
No.
And do you understand by entering this plea, there won't be a trial of any kind?
Yes.
And do you understand that you're giving up your trial rights, which are on page 1 and going on to page 2 of the agreement that you've signed?
Yes.
And do you understand that you're waiving any potential defenses that you may have?
Yes.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
All right. And what is your plea to the misdemeanor battery?
No contest.
I'll accept your plea of no contest is freely, voluntarily, and knowingly given, withhold adjudication, no violent contact with the victim, batteries intervention program, complete 50 hours of community service, or buy it out the statutory rate to a donation to a domestic violence nonprofit organization, credit for time served, 12 months of probation, a mental health evaluation, any recommended treatment, and the court costs were?
622.
867.
622 for misdemeanor.
It's a misdemeanor. 622?
That's what I
Yes.
believe.
Does that sound right? All right, $622 in court costs. All right, Ms. McGovern, do we have fingerprints in the file as part of the initial plea to the PTI?
Yes,
I
he's
don't-
already provided
I
fingerprints.
don't see it.
I don't think you would have one since it wasn't sentenced.
I didn't think so. I didn't, and I don't see them there. So, Ms. McGovern, I will need you to be fingerprinted based on this, although it's a withhold of adjudication on a misdemeanor, battery is an enhanceable crime, which means if you were to be charged with battery again in a different circumstance, they can make it a felony based on this. Do you understand that? Okay, I need to hear you. All right, so I need you to be fingerprinted for this, then you meet with probation, who's sitting back behind you. You have 30 days to appeal the judgment and sentence of the court.
Thank you, Judge. That's all I have.
Thank you, Mr. Tony. All right. Mr. Kleins, do you mind if I handle a couple that are on Zoom and have been for quite some time?
Sure.
All right. Why is it in basic? Go with Mr. Johnson and his client, Mr. Huggins. All right, Mr. Johnson, can you hear me? Mr. Johnson, can you hear me?
Judge, I'm here.
All right, can you hear me?
I do.
Okay. All right, this is your case, Mr. Huggins, who's also present via Zoom. What are we doing with the case today?
Judge, we have a motion hearing set on May 28th, so we would like to continue it.
What is set for May 28th?
There's two different motions to compels, and there's also a motion to modify the conditions of Mr. Huggins' release to remove the GPS because of the expense.
All right, when were those set? I don't see a notice.
No, we got the time from your office last week, and I think that notice will be filed today.
All right. All right, state have any issues with that?
Your Honor, I'm just checking, we'll be here that day, so without objection, Your Honor.
May 28th. Were y'all coordinated for May 28th?
I don't believe so, Your Honor. I'm not gonna swear to that, but.
Judge, we communicated through your office, and your assistant gave us that date, and it also went to the state.
Okay.
And they had asked us what motions, and I responded to that.
Okay. I know we talked last time that any motions were supposed to be set for before today, especially if there was going to be one with the special agent. So just trying to make sure everything's getting set in a timely fashion. All right, June 22nd for your next pretrial hearing. Make sure you file that notice today for the May 28th motion hearings.
Will do, Your Honor. Thank you.
All right. Can we not have any eating in the court, please? All right, thank you, Mr. Johnson.
Thank you.
All right, thank you, Mr. Huggins. 6:22 for pretrial and apparently May 28th for motion hearings. All right, Mr. Cruz, are you there? All right, I can't hear whoever that is for Cruz Law Group.
Good morning, Your Honor. I'm sorry, I was muted. I'm covering for Attorney Cruz this morning, Natasha Del Rosario, on behalf of the defendant.
Okay, which one?
I have Ricardo Morris, and that is case number 25 CF 240.
2400, okay. What are we doing with Mr. Morris?
Your Honor, we've reached out to the state. We're trying to get the case resolved. If we could just reset it, we're hoping to hopefully have a resolution by the next pretrial. If we could just reset.
All right, state? Anything? Whose case is it? Ricardo Morris?
Haven't heard anything about this case, sorry, I will look. Who's the attorney on it?
Cruz?
Tyrese Cruz would be the attorney record.
I wouldn't object to, I mean,
All right, June 22nd, 9 o'clock.
I haven't heard from anyone.
But the state claims, it says they haven't heard from anybody, so make sure Mr. Cruz follows up.
Yes, we've reached out to the state. We haven't gotten a response yet, but we were requesting,
Well,
trying to move forward with a resolution.
It's possible you could be reaching out to the wrong person because some of the cases have shuffled around, so reach out to Ms. Flowers.
All right, we will be sure to do that. Thank you so much.
I think Ms. Flowers just put in your notice to appear a couple of days ago or something like that.
Make a note to
Okay, then, we'll definitely reach out again. I believe that's not who we reached out to, but-
There's a new notice of appearance on behalf of the state that was filed, Thursday? So the case may have just shuffled to a different person. Make sure you're reaching out to Ms. Flowers.
We will do that.
All right, and then I think you also have Mr. Garcia Pena, but he's in jail, so he'll be on Wednesday.
Okay, that is,
All right, thank you.
thank you, Connor.
Have a good day.
You too.
All right, then I've got Mr. Ramey. Mr. Ramey, you appear to be in Washington DC.
I thought it was a good screensaver.
Okay.
How are you doing, sir?
Good. Who do you have, Mr. Ramey?
Judge, I have a couple cases. First one's in custody, Noah Brink.
Well, he'll be Wednesday then.
Okay. Next case is State versus Crenshaw.
Okay.
We had depot set on that case.
Hold on, just
last
that's
week.
Paul Crenshaw, 25 CF 1541. Go ahead.
Yes, sir, I'm sorry.
It's all
That's Mr. Sprouse's case. We had depot set last week, and unfortunately, my assistant sent the witnesses to the Fort Walton Beach State Attorney's Office instead of Crestview. I apologize to Mr. Sprouse about that, and we're working on getting a reset date on that. I just asked to put it on your next month's calendar, and hopefully we can get those depots completed and be ready to go forward.
All right. June 22nd, 9 o'clock for purposes of pretrial conference. Let's make sure those depots get set in the right place, Mr. Ramey.
Yes, sir. Next case is State versus Jordan Fisher, 24-1234 CF. We have depots set that should finish up the depots on May the 5th.
Okay. So are you asking for June then?
Yes, sir.
Without objection, Your Honor.
This case is almost 2 years old.
I haven't had it that long, but I understand, and I'm also engaging an expert that I'll be providing the state with his information so they can take the state depositions. of him.
Okay, well, that's kind of my concern. So if there's an expert that hasn't been disclosed yet, when's that going to happen so that deposition can happen?
I expect that will probably be next week.
Okay, well, again, the case is 2 years old, Mr. Ramey. I know even if you haven't had it that long, if you're going to be getting an expert, I just, these things need to happen a little bit faster. Otherwise, that's why cases get to be 2 years old and still aren't really ready to be resolved.
I understand, Your Honor. We could have the June 22nd date, everything would be good to go by that date.
All right, I'm going to say June 22nd at 9 o'clock. I'd like for anything that needs to be done with this expert done by then, but I understand the state will be probably pressed for time since they don't know who it is yet.
Yes, sir. And next case, Your Honor, is State versus Roy Simone, 25-22-26. Got out of that case, got back in the case with my firm not long ago. We've requested depot dates for the state, just waiting on them to confirm dates. Would ask for the June 22nd date. We should be able to get depots done between now and that date.
Just,
Without objection, Your Honor, I just want to make sure that you've sent us some dates, Mr. Ramey.
I'm sorry, I couldn't hear Ms. Bossoff.
Mr. Ramey, we just need to make sure that you send us some dates, and we'll fit you
Ms.
in.
Basso's probably better if you sit down so the microphone will pick you up better. You're standing to
Staying too close.
you're getting too far from the microphone.
All right, Mr. Ramey, I just need you to send me some dates, if you would, please.
Yes, ma'am, will do. Thank you. Get that out to you today.
Thank you.
You're welcome.
All right, there appears to be a misfiled plea and sentencing agreement in his case for someone else.
That's what we noticed too, Your Honor. I thought that was odd.
I think that case, it's handwritten, is case number 25 CF 2224, but the 4 kind of looks like a 6, so I can understand why it ended up in the wrong file, but if we can make sure that gets into the proper one. All right, so that'll be June 22nd, but let's get moving along with that, Mr. Ramey, since you've
Yes,
kind of
sir.
been in and out of it.
Yes, sir.
All right.
And next case, State versus Malachi Watkins. I understand he's still in custody. Also, it's 25-1791. Is he also should be moved to the next court date?
We'll see you on Wednesday for him,
Yes, sir.
429.
Thank you, Judge. That's all I have. Unless I'm in trial, I'll be there in person with you on June 22nd. Look forward to seeing you again.
All right. Well, glad to have you back in person, Mr. Ramey.
Thank you, Judge.
All right.
Have a good day.
All right, you too. That's everybody on Zoom. Mr. Kleins?
First I have in the gallery is Carrot Cope. And Mr. Williams is present with his client, who's the co-defendant.
Yes, sir, my client is Alex Offset.
What was the name of your client, Mr. Kleins?
Cope, C-O-P-E.
C-O-P.
He's number 86.
There it is. I've got it.
Your Honor, the situation with Mr. Cope is that we have deposed, I believe, all of the necessary potential witnesses. I need Mr. Cope to listen to these depositions because the state has not made a plea offer at this point. I don't think there's going to be a plea offer. I expect this is probably going to be set for trial next cycle, but I always tell my clients I want you to hear what was said at a deposition before you decide on whether or not you're going to set a case for trial. So the reason why I'm asking for this last continuance is so that he can review these depositions. Some of them were lengthy, relatively lengthy for depositions. So that's why I'm asking for a continuance here from Mr. Cope. I'm going to be expecting to set this case for trial next cycle if there's no resolution. But that's the reason why I'm asking for this continuance.
Okay.
Judge, our situation is the same, in fact.
What is your client's name?
My client is Alex Andra Offset. Alex and Andrew are two. It's 4625 CF 942.
Gotcha, thank you. All right. Same thing?
Yes, sir.
Okay.
And so Your Honor's aware, I've already talked with Mr. Williams, and we're probably going to listen to these depositions up at the Crestview Public Defender's Office because I'm the only one on the south side of the county. So suppose the 3 people coming down, I'll come up.
We'll also talk about it further, but at this point, we're not seeing a Bruton problem.
You're not seeing what?
A Bruton problem, so I'm anticipating the case will be tried again.
Together?
Yes, sir. That's
Okay.
what I'm anticipating.
You're a little bit away from the microphone, so I'm catching most of it, but just a little bit, it's kind of hard to hear, Mr. Williams.
I'm sorry, Judge. I'm not seeing a Bruton problem at this time, so I anticipate the state's going to move and the court's going to grant that the cases will be tried together. So it makes sense that we begin to coordinate together at this point.
State?
Yeah, the state can file a joinder, Your Honor. We have not at this time, though.
Do what you're going to do by then.
Yes, we will, Your Honor.
All right, let's put it on 6/22 at 9 o'clock. Ms. Offsack is on today's afternoon docket, but we're taking care of that now. Are you going to be here in the morning that day too, Mr. Williams?
Judge, I can be.
It's just up to you. Normally, the PD clients go in the afternoon. I'm trying to get the co-defendants at the same place, but if it becomes an issue.
I inevitably wind up needing to duck in for something.
Okay.
So I'll just make a note that I need to be there that morning.
Be your late morning.
Yes.
Okay. All right. Thank you, Mr. Williams. Thank you, Mr. Kleins. We'll see everyone back June 22nd at 9 o'clock.
All right. Well, I'll see you.
Next in the gallery, Your Honor, I have David Dimmers, followed by Marcus Dimmons. Mr. Dimmers is present and approaching. Your Honor, we need to take it, we're still waiting to take the deposition of the police officer in Mr. Dimmers' case. And once that is taken, I will know whether or not he has a valid motion to suppress. I would ask the court for a one-cycle continuance. However, I'm going to make a note that we need this depo taken before the next court date.
What's the reason why it hasn't been?
Just scheduling. I mean,
Okay,
we're-
and just the way you were saying it, I was,
Yeah,
wanted to make
well,
sure
I-
there wasn't some other issue.
No, I've got a number of cases where it's like we just need one depot and then it's ready to go. So there's a couple of these on today's docket that I'm going to be making a point to try to make that happen before June 22nd.
Okay. Whose case?
Oh, that's mine, Your Honor.
Okay.
The state has no objection.
All right, it's from August, so let's make sure it gets done before June 22nd, 9 o'clock for the next pretrial conference date.
All right.
So, but we had a couple today where officers out on leave or training or whatever. I just want to make sure the way you were saying it, that there might be some other hurdle of
Oh, no,
scheduling.
no. It's just, when I was going through the docket, I'm like, man, I need that one witness. I need that one witness. So, and this is Mr. Demmons, Your Honor. Mr.
25
Demmons,
CF 1314.
this is a plea or trial. I do expect a resolution next Monday. However, the case is old. It needs to be resolved. So we can leave this on the trial docket. Especially on Friday.
All right, we'll see you back on May 4th at 9 o'clock, plea or trial. State ready if it goes.
State
to
is
trial.
ready, Your Honor.
Okay.
Next, I have William Ewing, followed by Brittany Fowler. I'm just calling individuals in the gallery.
Okay.
This is Mr. Ewing. He's present and approaching. This is plea or trial. Mr. Ewing has been offered plea to misdemeanor battery for either 4 months county jail or a year of, 1129 of probation with anger management, no contact with the victim. If the case goes forward to trial, Mr. Ewing, as charged, currently scores about 23 months in the Department of Corrections.
Okay. Do you understand all of that, Mr. Ewing?
Yes, sir.
Okay. Have you had enough time to talk to Mr. Kleins about that?
No, we just told me about it this morning, you know what I
Okay.
mean?
Was a plea offer just made this morning? or-
No, Your
To
Honor.
me, it was, you know what I mean? He didn't call me or nothing to,
I
you
called.
have not called me.
Mr. Ewing, hold on, let him respond.
Called Mr. Ewing on Friday. He did not answer. He's come to my office for meetings. I mean, we've had physical meetings in my office. So, as a matter of fact, that 4-month jail offer was in response to him asking if the state would consider 60 days.
Okay.
So,
All right. Well, Mr. Ewing, we'll see you back on Monday, May 4th. That's a week from today at 9 o'clock. Obviously, talk to Mr. Kleins more about what's going on, but at that day, it'll either be a plea or set for trial over the next couple of weeks. All right. Thank you.
next in the gallery, I have Brittany Fowler, followed by Megan Greet. This is Ms. Fowler, Your Honor. This morning, she gave me quite a stack of papers that I need to go through and file in reciprocal. I don't know, I know it's an October arrest, but I think she has only had one previous docket day in January where she was unrepresented. So we have since been appointed to the case. I will get this information over to the state. We need to take depositions in the case. I would ask for a one-cycle continuance.
This is the second time up, but first time for you, Mr. Kleins.
Yes, last week when I was looking at the docket, I'm like, how is she just now getting to court with an October arrest? So
I think she had the PD and they
Right.
withdrew at the last pretrial. All right, 6:22 at 9 o'clock, Ms. Fowler. We'll see you back on that date. Make sure you stay in touch with Mr. Kleins. If there's any other paperwork that you've got, make sure he gets it so he can turn it over.
Your Honor, after Ms. Greek, I'll call, he's not on my docket, but Devontae Frederick is in the courtroom. And I looked on the last minute sheet, and he's supposed to be on today's docket. This is Miss Greek, Your Honor. This is her first time up.
So she's got two cases, 26 CF 89 and 90.
Correct. I would ask the court for a one-cycle continuance. Ms. Greek is wanting me to look into whether or not this can be suppressed. So I would ask the court to put this on the 622 docket.
Oh, there's like a double jeopardy going on there.
All right, 622 at 9 o'clock.
Mr. Frederick,
First time up.
this is Devontae Frederick, Your
You
Honor.
have a case number?
It's 25 CF 1273.
Looking at his minute sheet from last time, he was out of custody, so he was supposed to be on, he was set for today at 9 o'clock.
Yes. So the situation with Mr. Frederick, Your Honors, we did take the depositions in this case 2 weeks ago, I believe. If we could leave Mr. Frederick on for plea or continue, the state has already dismissed one of the cases. There's 3 co-defendants in this matter. There's Mr. Frederick, Mr. Elijah McClellan, and Mr. Byron Williams, Jr. The state has already dismissed the case against Mr. McClellan. The state is considering dismissing the case against Mr. Frederick. I'd like to leave this on for next Monday so we can get a decision on that before, hopefully if the case ends next Monday, great. If not, we'll set it up for trial next cycle.
No objection. There is a likely resolution.
Okay. Can we make sure, did y'all get the case number? May 4th at 9 o'clock. It's called plea or continue.
All right. Next in the gallery, I have Arlen Hickson, followed by Julia Lynch. Miss Hickson is present. Your Honor, this is her first time up. We're going to ask the court for a continuance so we can take some depositions in this matter.
Without objection, Your Honor.
All right, June 22nd to set depositions. It'll be at 9 o'clock on June 22nd, Ms. Hickson. We'll see you back that date. Stay in touch with Mr. Kleins.
Next, I have Julia Lynch, followed by Jennifer Money.
Lynch is here, 26 CF 360.
We were just appointed to Ms. Lynch's case on the 17th. We don't have discovery yet. I would ask the court for a one-cycle continuance.
It's the first time up, June 22nd, 9 o'clock.
We'll get discovery out and it hasn't been sent already.
Okay. All right.
Next in the gallery, I have Jennifer Money, followed by Susan Slingerland.
Money, 26 CF 158.
Your Honor, this is Miss Money. I believe this is her first time up also. Miss Money has indicated to me that she has reciprocal discovery that is on her phone that she needs to take to a phone repair guy so she can get it off the phone. Because I'm trying to get reciprocal discovery, assuming that it's going to be on this phone, I would ask the court for a one-cycle continuance.
No objection.
The phone needs to be repaired before you can do that.
Screen's cracked.
Okay.
You can't, like, touch anything.
All right. June 22nd, 9 o'clock, first time up.
While she's here, Your Honor, she does have 2 cases. One of them is not on this docket. I just want, if we can put them all together, this is the 158 case. She also has 25 CF 2340. So if we can just continue both of these matters to the 622 docket.
That one was on, let's see, 223 was set for 427 at 9 o'clock. All right, so let's make sure 25 CF 2340 is set also with this on June 22nd at 9 o'clock.
Susan Slingerland. If we could skip to Jacqueline Stacy.
Jacqueline Stacy.
Your Honor, we do have a plea agreement to resolve Ms. Stacy, if I may
There she,
approach.
I'm sorry, I couldn't see her. She was behind you.
May I approach?
Yes, sir. Thank you. All right, Ms. Stacy, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name and date of birth, please?
I'm Suzanne Stacy, January 20th, 1986.
Okay, and Ms. Stacy, you're here in 25 CF 2278, where you're currently charged with possession of a controlled substance, third-degree felony punishable by up to 5 years in state prison, as well as a misdemeanor first-degree count of obstruction of the execution of a warrant. Do you understand that?
Yes, sir.
All right, I have a plea and sentencing agreement between you and the state that calls for you to plead to a lesser included offense on count 1 of possession of drug paraphernalia. That'd be 893.147. And in return, it'd be time served, court costs of $270 on a misdemeanor, I believe, non-traffic. $50 application fee and $50 cost of defense, and then count 2 would be null pros or dismissed by the state. Is that the agreement that you've made?
Yes, sir.
Okay, did you go over this agreement with your lawyer?
I did.
Did you need any more time to do so?
I do not.
All right, did you understand and sign it?
I did.
Okay, and are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Did anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
It'll also be an adjudication of guilt. Do you understand that?
Yes, sir.
Okay. And has anyone promised you anything other than the terms of the agreement that I've mentioned?
No, sir.
And do you understand that by entering a plea, there won't be a trial of any kind? You understand you're giving up your trial rights, which begin on page 1 and go on to page 2 of that agreement you've signed? And do you understand that you're waiving any potential defenses? And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? All right, and what is your plea to count 1 lesser included offense of possession of drug paraphernalia?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on count 2. All right, count 2 is now processed by the state. In return, your agreed upon sentence on the paraphernalia charge is time served, $270 in court costs, $50 application fee, $50 cost of defense. Ms. Stacy, I'll give you 60 days to either pay those costs or set up a payment plan with the clerk's office. You can do that downstairs on the first floor. Also an adjudication of guilt, but I don't need fingerprints. You don't need to see probation because you're not on probation, but you do have 30 days to appeal the judgment and sentence of the court. Thank you, Ms. Stacy. Have a good day.
Thank you.
Your Honor, going back to people I did not call that are not here, on Mr. Dennis Brooks, could we approach briefly on Mr. Brooks?
Mr. Brooks, okay. All right, so Mr. Brooks will be 6/22, 9 o'clock for purposes of pretrial. Did y'all want the July 30 for the order to show cause date?
We can do that, and I'll go ahead and put that in the order.
All right, put that in the order, but, so you don't have to set that yet, but they're gonna send me an order.
9 o'clock on that morning, Your Honor? I mean, it's,
Yeah, let's do morning.
okay. All right. Then I did not call Michelle Kahn. We did file a waiver for her. I would like to leave Ms. Kahn on for plea or continue so I can try to make contact with her this week. We've been playing phone tag and emails and all. She's been trying to keep in contact with me, but I have not physically talked to her since I've been appointed to her case. So I'd ask the court to leave this on plea or continue for next week.
Let's get her in. May 4th, 9 o'clock.
Next, I have Susan Ford in 25 CF 560. This is an older grand theft auto case. We did attempt to take the deposition of the alleged victim on April 1st. He was not found. Since then, the state has filed updated address. This is one where I would ask the court to continue this one last cycle. I did talk with Ms. Ford. She's currently in the hospital recovering from surgery. And I told Ms. Ford, basically, like, look, I can do a Zoom depo. Like, we can do this on a one-off. If I can find 15 minutes with Mr. Sheik somewhere and we can get the alleged victim, we don't need to shoehorn this in with another date where I'm taking tons of depos. So I do expect we should be able to depose this individual. He's in Ocala. I don't have a problem with him appearing by video as long as we can confirm his identity. So this is one where I do expect plea or trial, or it might get dismissed. I don't know, because I've never talked with Mr. Alford.
Okay.
But we can continue this one last
So
time.
next time it's either gonna be a plea, a trial, or continuance,
Well,
or dismissal, or,
It's getting to the point, honestly, with this situation where I'd be okay just saying plea or trial. But Ms. Ford wants me to try to take his deposition, so I'll do that.
all right, June 22nd, 9 o'clock. I'm gonna call this last continuance. The case is over a year old.
Yes, sir, and I'll make a note of that. And then I have Charlie Gullett. I did talk with Ms. Gullett a couple weeks ago. There's a potential motion to suppress with Ms. Gullett. We did file a waiver late last week. I would ask the court to continue this to 6/22 so we can get these depositions taken, and expecting there's going to be a motion to suppress.
All right, that's the first time up, so June 22nd, 9 o'clock.
I have Victoria McLeod in 25 CF 1000. Ms. McLeod, we filed a waiver on Ms. McLeod. The state has agreed to extend a PTI agreement to Ms. McLeod. I need the paperwork from the state this week. Ms. McLeod's been in regular contact with me. So we can leave this on for next Monday, plea or continue, but I expect a resolution.
All right, May 4th, Monday, plea or continue, 9 o'clock.
And then Susan Slingerland? Ms. Slingerland was present this morning. I talked to her. She gave me her phone number. We talked about the potential minimum mandatory here. I don't know where she went. If the court would allow me to continue this to the 22nd of June.
Why don't we check the hallway and find out if she's here? Did you talk to her this
Oh, I
morning?
physically talked to her. As a matter of fact, I have a note on here that she knows about the minimum mandatory, because this is a minimum mandatory situation.
All right, I'll put it on May 4th, maybe, I mean, I know it happens sometimes, they talk to you and they think they can go, so
Yes, sir.
May 4th, but if she doesn't show up for that, then it's gonna be a KPS.
Fair enough. And I believe that's all I have this morning.
I've got some more with your name on them, let me just double check them.
Singletary should be in custody.
Yes, there were a number of-
Singletary's in custody?
Yes, sir.
Okay.
Johnson.
Oh.
I think should be in custody. Nope.
All right,
We
so
can leave Mr.
can-
Johnson on for Wednesday, though, because he did come to court last.
Well,
time.
anyone who's in custody is gonna be brought for Wednesday.
Well, he's not in custody, though.
No, I think he was arrested Thursday.
Oh, was he?
Yes.
Yes, he's in,
He has a pretrial detention hearing this
as of
Thursday.
Friday, he was in jail.
So things are looking up.
Probably not, but it's scheduled.
Yeah, I got the email at 10:16 this morning that he's got a pretrial detention set for Thursday.
Oh.
I only knew because I was in first appearance and
Well, he'll be here on Thursday and Wednesday, so.
All right, so we'll see him on the 29th. That's Johnson. Singletary's in jail as well?
I'm gonna go see him
So that'll
here.
be the 29th. I had some others. That's fine.
Tristan Colley, was that?
Jordan Cook, I continued that already, right?
You did, he's in custody too. Tristan Colley's in custody.
Are we gonna have Cook on,
I don't think so.
so it's not, it's gonna be June 24th?
Correct.
Okay.
Yes.
I remember the name that I signed it, I just couldn't remember if it was,
There were a number that you had signed, so I've already told us a number of these individuals, like, hey, as soon as I see your name on the list, I'm gonna take you off, like.
all right, Michelle Kahn?
That's the individual we kept on for next Monday. We played phone tag and email.
Oh, I wrote it for her other case, but
Yes.
there's two. All right,
Yeah.
that's my fault. Tristan Colley, you said something about him.
He's in custody.
Custody, 429. Bradley Anderson?
He's in custody.
Custody. Oh, that's Bradley Anderson again. All right, I think that's everyone. Do you have anyone else for Mr. Kleins? Okay.
Well, I'll see you on Wednesday morning.
All right, and then I have Ms. Rolandi. All right.
Morning, Your Honor.
Morning, Ms. Rolandi, and let me just announce your case real quick. It's 24 CF 162. So Mr. Cobb was up here. I know you were in the room when that happened. So I previously, at our previous court date, what was it, March 5th, I think it was?
Yes.
That you had wanted him removed from your case. Then I realized that I think there's a conflict here between the two of you, and so I allowed him to withdraw, but I wanted to talk to you more. And I think we talked about this last time, about doing what's called a Ferretta hearing. And then I said, well, we've talked a lot today. I've got a few more cases to take, and I'll see if I can fit you in before the end of the day. And then we didn't finish till after 5 o'clock, and I think you were gone. Not complaining about that. I'm just kind of setting the record. And then so you're here, but you're not currently represented. Do you want me to potentially appoint someone else to represent you?
No, Your Honor.
Okay, so you want to represent yourself?
Sorry about my voice.
You're okay. You're okay.
Yes, Your Honor. 'cause
Okay,
I
raise your right hand then.
I know I'm not alone.
Hold on just a second. Do you swear or affirm that testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, can you state your full name and date of birth, please?
Edith Elizabeth Rolandi, July 1st, 1979.
Okay, so Ms. Rolandi, how far did you go in school? These are questions I have to ask for a hearing.
Oh, I understand. Associate's degree.
Okay, so some college. And you got an
Yeah, I'm a
associate's degree.
registered nurse, so I have, that
Okay,
degree.
I do remember that now, but.
Yeah, and it's only an associate's. I didn't get my bachelor's in it.
Oh, it's fine. I just want to make sure. So you read and write well?
Yes, sir.
Okay. Again, I have to ask kind of the same questions to everybody, even though I think I know the answers. I just have to ask the questions as part of how this works.
I understand.
All right. And have you ever represented yourself before?
No, sir.
Okay. And have you done anything to familiarize yourself with the laws of the state of Florida?
I mean, I've done some research.
Okay. And do you understand the benefits of having a lawyer representing you?
I understand that. Like, I do respect the amount of time sacrifice that people put into becoming a lawyer. And I'm not saying that I'm standing here trying to be a lawyer. I just believe that Yeshua the Messiah, Jesus the Messiah, is with me wherever I go. He tells me that he will not leave me nor forsake me. And I believe.
Okay, I just need
Yeah.
you to answer my
I'm
question. So,
sorry.
do you understand that there are advantages to having a lawyer, such as that person has gone to number one law school,
Yes,
has passed the bar exam,
yes,
and typically has practiced criminal law for some time before they could be put on the list where I can appoint them to your case?
yes.
Okay.
I understand that.
So do you understand that they have a lot of knowledge and experience in how these cases work?
Yes.
Okay, and have you ever had a case where you've been involved at all in a criminal case?
No.
Okay, so you don't have really a whole lot of familiarity with the court system?
No.
Okay. Have you done anything to review the rules of criminal procedure in the state of Florida?
Yes.
Okay. And do you think you understand them?
I mean, they're very complex.
That's part of the issue, is they are very complex. In
it's
fact,
not
I
like-
have to reread them all the time, so.
It's like, the law that I love, which is the Lord's law, it's black and white, but for some reason, like, this law is very complex, but I do believe that I understand them.
Okay. All right, and we kind of went over the reasons before back on, I think it was, again, March 5th, as to why you didn't want Mr. Cobb to represent you anymore. And I didn't make any ruling that he was ineffective in any way, but just simply that y'all had got cross enough with each other that there was a conflict of interest there.
Yeah, I believe I was like very patient. Like for the first year, I pretty much, let it be just trusting. And then a year went by, and then close to 2 years. So, and now it's like 2.5 years.
Okay. And I understand that, and as you realize, I didn't have the case until, I think it got assigned to me in December of '25, so just about 5 months ago.
Yes.
So I'm not terribly familiar with how things were going at that point, other than what I've tried to go back and watch some hearings in the past, but I'm just trying to make sure that you've had a chance to kind of revisit some of those things. Now, do you understand, because you've previously been found to be indigent, that I can appoint you a different lawyer?
I understand that, but I mean, look what happened with me with Mr. Cobb that was appointed
Okay.
to me.
All lawyers are different, you understand that, right?
Yes, I do.
I'm sorry, is someone texting you?
No, that wasn't me. I'm just.
Because I heard a phone buzz and then you looked at it and then.
Oh, I'm sorry.
All right, so I'm gonna ask you.
I think it's just like a natural instinct when you hear
If
something.
you could just turn your phone over or put it away.
I'm sorry.
Because my concern is you've got people here in the audience maybe texting you.
Oh, yeah, no.
Is that what's happening?
No, I should have brought my paper like last
Okay.
time. But it just has like some key things that I do want to go over.
Okay.
After this is, if you.
I
grant me
understand, but I
those
can't
things.
have people sending you messages
No,
during. Miss
no.
Rolandi, if I could finish. I'm not trying to interrupt you, so let me just make sure when I'm saying
Yeah.
things, it's for the record. I want to make sure these things are said. That if you're receiving text messages from someone else in the middle of this inquiry, we're going to have some concerns.
No, Your Honor, that's
Okay.
not happening.
All right, so then you don't need your phone anymore, do you?
Not at this time.
Okay,
I do have a list of things that I do, after this part of me, after the Feretta hearing,
Mhm.
that I would like to bring to your attention.
okay, we can potentially discuss that. All right, so do you understand the disadvantages of not having a lawyer?
Yes, sir.
Okay, so you know a lawyer has experience and knowledge of the entire process, whether that's be discovery, filing motions, preparing for trial, selecting a jury, conducting a jury trial. You
Yes,
understand,
and
you don't have any of that, right?
I don't have any of that experience, Your Honor, and I respect the sacrifice, the hours, probably sleepless nights that people spend, becoming a lawyer. I do respect that.
That's
But-
not my question, though, Ms. Rolandi. My question is, do you understand it's a disadvantage to be an inexperienced person not having an experienced lawyer?
Yes, sir.
Okay. And do you understand that if I ultimately rule that you can go forward and represent yourself, and you go to trial, if you were convicted, you can't really come back and say, well, I should have had a lawyer, because you're making that decision. That's what this is all about.
Yes, sir.
Okay. And do you understand how to file a motion?
Yes, sir.
How do you do that?
Well, you write it out, and you put it on the Okaloosa County Clerk's office, and you present it before you.
All right. Have you looked into filing any motions in this case? I'm not asking what they are, I'm just asking.
Yes, sir.
Okay. All right. And do you understand how to subpoena a witness?
Yes, sir.
Okay. And do you understand how to question witnesses?
I'm gonna learn that.
When do you plan on doing that? 'Cause you've told me, not just today, but your case is very old.
Yes.
And
mean,
I would intend to be setting it for trial soon if you're ready for that.
I'm also presumed innocent and the burden lies with the state.
Okay,
And
that's not the question I'm asking, though. So I don't want you to be kind of confusing or conflating these issues together. Yes, the burden is always on the state to prove a case beyond all reasonable doubt. However, do you understand how to question a witness? What questions might be important? What kind of things you might not want to ask if you don't know the answer to them?
Yes, I mean, I'm gonna do further research and, I mean, I briefly looked it over and I'm gonna continue my research with it.
And how do you plan to research it?
Going to the library, law books,
Okay.
YouTube, I'm sure has a lot of, you know,
Have you ever watched a trial?
I think in here, I watched someone being questioned.
Okay, but have you ever watched a trial, a criminal trial?
No.
All right, and do you understand that a lawyer can give you advice as to whether or not you should testify in your own case?
Yes.
And they can give you advice on the consequences of that decision and what you have a right to not say.
Yes.
All right, so you're giving up that potential advice, right?
Yes, I am.
If you want to represent yourself. Okay. Have you ever studied anything to do with the evidence code in the state of Florida, specifically Chapter 90 of the Florida statutes?
No, I haven't studied that.
Okay. Do you know what hearsay is?
Oh, I've heard that before.
Okay, what is it?
It's something that could be used in the courtroom to say like something's not relevant because it's just been heard by, it's hearsay. It's not, doesn't have factual basis behind it.
No. So hearsay is something that's been an out-of-court statement made by somebody that's being used in court to prove the truth of the matter asserted, the truth of what was said outside of court. Do you know if there's any exceptions to that rule?
I mean, an exception would be if somebody participated in the situation, maybe was a witness or can be considered a witness.
Have you ever familiarized yourself with Florida Statute 90.803?
No, sir.
Which is the hearsay statute, or the exceptions to the hearsay statute?
No, sir, but I will look these up.
Okay. You ever seen a jury selection process before?
No, but I believe that my case has statute elements and that should be brought before you because you know the law, and I believe
I don't know what that means. What do you mean by that?
I mean, criminal intent, culpable negligence, causation. I believe that the state's not going to be able to prove that
What does it have to do with jury selection, my question?
because I want my case to go before you. So
You want to waive your right to a jury trial?
Yes, sir.
All right. Do you understand the state has a right to a jury trial as well?
I understand that.
Is the state going to be willing to waive its right to a jury trial in this case?
Your Honor? It's actually Ms. Leone's case, Your Honor. I cannot say that she's ready to do that at this point now.
Okay.
Also, it has been waived for a related case.
That your case, although it can be related as far as facts, as far as people's rights and the state's rights, and those have to be independently determined.
Okay.
Have you ever watched a jury selection before?
No, but I will familiarize myself.
Okay.
with this.
How do you plan on doing that?
Research. You have a library, I know in Okaloosa.
Have you been to the library?
The Okaloosa Courthouse has a library.
Have you been there?
I've been to the library.
Have you
Not
been
to
to-
that specific one, but I have been to the library.
Well, there's a big difference, right?
Fort Walton Beach, Florida Library.
Okay.
But
So have you
but I
been?
live right in Fort Walton. I'm sorry, Your Honor.
Have you
Go
been
ahead.
to the law library at the courthouse in Fort Walton?
No, Your Honor.
Okay. You understand that you have a constitutional right to a jury trial?
Yes, sir.
Did you ever discuss that issue with a lawyer?
No, I haven't.
Okay, so you've never been given any advice on whether or not you should waive your right to a jury trial?
No.
Okay, do you understand that if you go forward with what's called a bench trial or judge trial, and if I find you guilty, then you don't get to come back and say, well, I want a jury trial now?
I understand that.
Okay, and the reason I ask is there are some states where that is the case,
Okay.
but this is not one of them.
Okay.
All right, so you understand if I rule against you and find that the state has proven their case beyond all reasonable doubt, you can't come back and say, well, I'd like my jury trial now.
That's right.
Okay.
I agree.
I think Alabama, which is a neighboring state and very close by, has some rules where you can actually do that. All right. Have you ever seen anyone give a closing argument in a case?
No, Your Honor.
Okay. Do you know what sort of objections that you can make during the state's closing argument?
No, Your Honor.
Okay. And do you know how to preserve issues for appeal? If you think I make a bad decision, do you know what you need to do to preserve those things for appeal?
I believe you state, like, I would like to preserve this for the record.
Okay. Do you understand if you have a lawyer and you were to be found guilty in your case, that they can bring post-trial motions in order to either preserve things for appeal or potentially ask for things to be reconsidered?
Okay. I am aware of it now.
Okay. And do you understand that having the kind of legal experience and skill necessary to determine those things is not something that you would have, right?
I understand that.
Okay. And do you understand that you're not going to get special treatment from the court just because you'd be representing yourself?
Yes, sir.
Okay, do you understand I have to require you to follow all the same rules as any attorney who appears in front of me?
Yes, sir.
And do you understand that you're not entitled to continuances simply because you want to represent yourself?
Yes, sir.
In fact, you've made a comment about how long this case has taken, so it's the
Yes.
court's intent to go to resolve this case.
ASAP.
Well, not as soon as possible, but as soon as
It's
it
like
can
a-
be done.
Right.
All right. Just want to make sure I'm not missing anything. Do you understand? And I don't ask this question because I don't think you've ever been this way, Ms. Rolandi, but do you understand that if you're disruptive in the courtroom, that I can terminate your self-representation and or even have you removed from the courtroom?
Yes, sir.
Again, you're nothing but polite every time you're here, but I have to ask the same questions. And do you understand if that were to happen, that the trial could continue without your presence?
Oh, wow. Okay. Yes, sir.
Again, I don't perceive that to be an issue, but I want to make sure I'm covering everything. And do you understand that since you can only really discuss anything with the prosecutor in open court on the record, that it restricts your access? You know, a defense lawyer could have email conversations, phone calls, talk to them in the hallway, and you won't be able to do those things because they have to follow their ethical duties as well.
I see. So okay, so that is a difference. Okay. So in here, I have to like represent myself and like bring my motions forward as a lawyer, but outside of the court, I can't discuss like my case with the prosecutor.
With the prosecutor, no, because they have to make sure everything is on the record.
Okay, I see. I understand that.
And you can understand why, is because if there's conversations, then someone may say, well, that's not what they told me out in the hallway.
Yes.
That's
and
why everything has to be done on the record.
And as a lawyer, they made an oath.
Yes. And you understand that the state's not going to go easier on you because you're representing yourself.
I understand that.
Okay. And do you understand that if you're convicted, you can't claim on appeal that your lack of legal knowledge constitutes a basis for a new trial?
I understand that.
Okay. Because if a lawyer represents you and doesn't do a good job, you could come back on what's called the 3850 motion and say, my lawyer was ineffective, and I'd like to revisit some of these issues or even come back for a second trial. Do you understand that?
Yes, sir.
All right. Do you have any questions about the dangers and disadvantages of representing yourself in a case like this?
No, sir.
Have you received a copy of the information or charging document against you?
Yes, sir. I received an amended, I know it was amended 2 times, so I had
Okay.
like 3 different times of charges. I did receive the one from September 9th. It was 2 days before my motion to dismiss hearing. But I didn't receive like,
And that was a reduction in the charges, basically, right?
yes.
Okay.
I didn't receive a criminal point sheet.
Okay.
I know my lawyer spoke, because I was offered PTI, and there was like discrepancies of the factual information on it.
What factual information?
It was about going to the emergency room the next day, but it was actually, we went to a urologist.
Okay.
And I wanted to make an informed decision, but he never got things clarified. He never told me like specifics. Is there a way to get the criminal point sheet?
Has one been generated by your office, Ms. Basso? I know you're covering the case.
Yes, Your Honor, it looks like Ms. Berkman actually generated it back in October, but we can certainly get one to Ms. Rolandi.
Okay. And my understanding is she's charged with child abuse without great bodily harm, child neglect without great bodily harm, and false information in law enforcement. So those are 2 third-degree felonies, level 6, which I think may lead to her scoring. I don't have a score sheet in front of me with all the
Your
points.
Honor, it looks like it's gonna be 72 points according to this score sheet.
Okay, so what?
That would, she would score to that. Let me just-
Okay, so that, what would that number come out to is a, and again, don't take this as me trying to say what you should do or shouldn't do, but just so you understand, since you brought up this particular issue.
Your Honor, it's 33.15 months as the minimum guidelines.
Okay, so what that means, Ms. Rolandi, is if you go to trial and are convicted as you're charged, that you would score 33 months in prison. Do you understand that?
Okay.
Okay, and now you can, if you were convicted of those things, you could still make an argument to the court as to why I should do what's called a downward departure and do less than that. Have you ever familiarized yourself with the downward departure statute?
No, Your Honor.
Okay.
But I will familiarize myself now that it has brought to my attention.
Do you understand that if you're convicted and we want to argue a downward departure, that it's your burden then to prove why I should, that you're eligible for a downward departure and also that I should do a downward departure?
Yes, sir.
Okay. Because if I find that you haven't put on sufficient evidence to do that, I'd have to sentence you to at least those 33 months.
Okay.
Do you understand the charges against you as far as what they are?
Yes, sir.
And during the time that you were represented by counsel, did you discuss your case with him?
Yes, sir.
Also, since you're charged with 2 third-degree felonies and a first-degree misdemeanor, again, those are punishable, the 2 felonies, by up to 5 years in state prison, as well as the misdemeanors a year in county jail. Do you understand that?
Yes, sir.
Okay. And do you understand that those could run consecutively? Which means it could be 5 and 5 and 1. For a total of 11.
Okay.
Okay. You understand that I could sentence you to probation if you're convicted?
Yes, sir.
And do you understand that I could have you pay fines or restitution, and court costs?
Yes, sir.
Okay. Do you understand if you go to trial and or are convicted, that you'd have a permanent criminal record?
Yes, sir.
And potentially, if convicted of a felony, you'd have a felony conviction?
Yes, sir.
And do you understand if you're not a U.S. citizen, you could be, if you're found guilty of any of these charges, that you could be deported or excluded from the country?
Yes, sir.
Do you have any questions about any of those things?
No, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Have you ever been diagnosed or treated for a mental illness?
No, sir.
Do you have any physical problems that which would hinder your self-representation specifically? Or I guess you can come up and tell me anything that you think might fall into this, a hearing problem, speech impediment, poor eyesight?
No, sir. I mean, I wear glasses, but I wear
Okay.
contacts.
Me too.
So.
Okay. All right. Has anyone told you that you shouldn't use a lawyer?
No, sir.
Has anyone threatened you if you hire a lawyer or accept a lawyer appointed by the court?
No, sir.
Again, do you understand that a lawyer appointed by the court will represent you for free other than an application fee and $100?
Yeah, I had one. I paid that for Mr.
So you already
Clark.
paid the application fee?
Yeah.
So going forward, it would only be $100 if I had you represented?
Yes, sir.
Okay.
I mean, is there such thing? There is such thing as a standby lawyer.
Well, do you understand, if I appoint a standby lawyer, that means at some point they can jump in and take over.
Oh, without my permission?
No,
Or-
well, if I decide that I can't let you represent yourself anymore because of how things are going, I could potentially do that. Are you asking for standby counsel?
Possibly, because all the questions.
Well, ma'am, as you said, this case is almost 2.5 years old. It's time to make these decisions.
Yes, sir.
I don't want to try and force you into anything, but these things have to be considered and a decision has to be made.
Okay. With a standby lawyer, does that mean that I can go to him and ask those questions of those statutes that you
They're
told
either
me?
your lawyer or they're not, but they're not here to assist you as
Okay.
far as suggesting what you should do.
Understanding the
And
hearsay,
yeah, they're not going to elbow you and say you should object to this.
okay, no, that's not my question. My question is, because I'm gonna research, the hearsay statute that you told me about, those,
Well, I can tell you, I don't know about where everyone else went to school, but hearsay alone was almost half a semester in one of my evidence classes.
okay. Because could I use him as a resource to answer questions like that? Or her?
I mean, they're either going to represent you or not. They're not going to work as kind of your paralegal or research assistant or anything like
Yeah,
that.
no, I wouldn't, it wouldn't be like a paralegal, but it would be just somebody that, ask those specific questions to. So can you tell me what a standby lawyer specifically
They're basically
does?
standing by in case you decide at some point, I can't do this anymore. Or I decide, based on what I'm seeing and I'm observing, what I'm hearing, that I don't feel you can do it. Then I can
Okay.
say it's time for the standby lawyer to come in and take over. But it's not a tag team situation. They don't do parts of it, and then you come in and do parts of it. You're either representing yourself or you're represented. It's not a bouncing back and forth.
Okay, so that I could understand this, so is it, so say so I want to go pro se, and then I have the standby lawyer just in case this isn't what I was expecting and I can't do this. It's not to prolong things. That person's there that could just jump right in.
But again, they're not going to be working your case.
Oh,
They're just there
okay,
to do their best that they can, given the situation they'd be handed.
okay,
But they're not going to be researching your case, talking to witnesses, all those things, because they're standby. It's not until they're actually representing you do they start doing things for your benefit.
okay. I mean, I think I would feel comfortable getting a standby lawyer if you grant one to me.
Right? Is that what you're asking?
Yeah, I would accept I'm asking for a standby lawyer.
All right, do you have any other questions about me appointing a lawyer to defend you or not?
No, sir.
All right, having been advised of your right to counsel, the advantages of having counsel, the disadvantages and dangers of proceeding without counsel, the nature of your charges, possible consequences in the event of a conviction, are you certain you do not want me to appoint a lawyer to defend you?
Yes, sir.
All right, and if I allow you to represent yourself and you request it, I could have either a public defender or an appointed lawyer act as standby counsel, and he or she would be available to you if you have questions in the course of these proceedings. But again, they're not to kind of jump in and out of the case like that. Would you like standby counsel?
Yes, sir.
To be honest with you, Ms. Rolandi, I'm not sure at this point if I feel comfortable with you representing yourself, that you truly understand the gravity of the situation, that you've done any work to prepare yourself, and how quickly you're going to be able to do that.
Well, I know that you said that has nothing to do with this, but
Or you have a right to represent yourself.
Yeah.
So my concern is not allowing someone to exercise one of their fundamental constitutional rights. My concern is that you're not ready for it because of some of the relatively simple questions I've asked you. For if I would ask a lawyer, they could tell me all sorts of things, that because they've been studying not only in law school, studying for the bar exam, and most of the lawyers who would be potentially appointed to you have been practicing for years, some of them decades.
Right. I guess the way that I see it is that the burden lies with the state, and I anticipate that they have insufficiency as far as criminal intent, negligence, and causation. So I feel like,
You understand a lawyer wouldn't list the weaknesses of the state's case to them necessarily.
because they'll go and try to strengthen it. But they can try all they want, but they still have insufficiency.
Okay.
It's up to you.
Well, I understand. And what I'm trying to do is make sure that you're not making a bad decision for yourself.
Right.
Have you ever had a public defender representing you?
Yes, okay, so what happened was the first public defender, I guess, my husband had initially too, so there was like conflict of interest.
Okay.
So then he couldn't do it. And then, what was her name? Then there was a female attorney. And the same, like, I guess, when the charges were finally placed, because it took a long time for the state to up my charges.
Was that Ms. Jaquette?
Yes.
Or Jaquette, I'm sorry.
And then she just wrote in that she couldn't represent me. And so then,
Do you know when that was?
that was early on, right before I had Attorney Cobb, because then he was appointed to me. Because the charges were elevated after there was the medical evidence that my son was perfectly fine and
No,
healthy.
I understand. So I'm looking at the motion to withdraw that had been filed. So the public defender withdrew because they were representing Mr. Rolandi.
Mhm.
And then back in April of '24, so 2 years ago, the Regional Office of Conflict Counsel moved to withdraw. Didn't really give a reason other than they certified there was some conflict of interest.
Yeah, there's been a lot of that kind of stuff.
So the only thing I can really do, Ms. Rolandi, is because of the procedures, you've already had a public defender, they've withdrawn because of conflict.
Mhm.
You've had Regional Office of Conflict Counsel, they've withdrawn because of a conflict. And a previous court has determined that,
Yeah, but
Ms. Rolandi, if I could finish. So my only thing I can really do at this point is to appoint you a lawyer like Mr. Cobb was, a private lawyer who takes these types of cases, and they could potentially be your standby counsel.
Okay. So, can I ask you a question? When
I
it's
can't give you legal advice, but you can
Okay.
ask me a question.
When it's conflict, does it make it look like it's me that's being conflicting?
It does, like I said, it doesn't even say why. Usually it's because they represent someone who's either related to your case or something like that.
Okay,
For
so-
example, the public defender can't represent both you and your husband because you're both basically charged with the same thing, right?
Right.
Or at least related things. I don't know why the Regional Office of Conflict Counsel withdrew from your case,
Mm-hmm.
because there's nothing spelled out in their motion other than they were certifying a conflict. Sometimes they only put that in their motion because they don't want to put that information in the court record as to what the conflict is, because they think it might either give information to the prosecution, it may give information to the judge that you may not want them to know. So
Okay.
that's why sometimes it just says that they certify the conflict for that reason.
Okay.
But if they've already made that determination, I can't just reappoint them, so I'd have to appoint you standby counsel who's a private lawyer like Mr. Cobb was.
Okay, understood, Your Honor. I just didn't want it to appear like it was me.
No,
with Mr.
and I
Cobb.
certainly don't take it as that.
Okay.
Even when, as I determined with you and Mr. Cobb, there's some conflict between you, I certainly wouldn't place that on you or Mr. Cobb, just simply after the time that's passed. Y'all have gotten to a point where there's kind of irreconcilable differences or irretrievable damage to the attorney-client relationship. And I don't assign any sort of blame in that situation. Sometimes that just happens. I can tell you, I was a defense lawyer for 15 years of my 17 before I took the bench. So I understand how that happens. And I've gone through those things before on a personal level, with clients. So sometimes it just doesn't work out anymore. And sometimes it's the best thing for the client, which is the important part, best thing for the client to have a different lawyer because things just aren't really working well anymore.
Understood.
All right. All right, so at this point, I'm going to find that you're competent to waive counsel, but I'm going to appoint standby counsel. Do we have someone who's next in line? Mr. Nopes.
Okay, yes,
Okay.
I've seen him before.
And he's been in here, he's here most of my court dates. I'm gonna appoint Mr. Nopes as standby counsel. You can certainly discuss things with him. To the extent he can give legal advice, he can do that. But again, it's not for y'all to work tag team, going back and forth and working in a situation where he's doing parts of the trial and you're doing parts of the trial. He can certainly give you advice on whether or not waiving your right to a jury trial is the right decision for you.
Okay.
Again, I can't give you any sort of counsel or advice on that. And again, I have to wait to find out if the state's going to waive their right, because it's kind of both sides have to do that. Both sides kind of have to turn their key and say, yes, we don't want to have a lawyer. I know that happened in your husband's case before I was involved in it, but I'm not sure if they'll make the same decision in your case.
Okay.
All right.
Your Honor, prior to Ms. Verlandi moving on, I do have a copy of the score sheet if she wishes it.
Okay.
Yes, please, thank you.
I just changed it to Ms. Leone and to Judge Oberliesen because
Okay.
it said Judge Stone on it.
Okay.
Yes, ma'am, that's for you.
Okay. So, again, it depends on, that's if you were to be convicted as you're charged. Obviously, if you got convicted of one or two of the three, things would change, and so that would have to be amended. But if you're convicted as charged, that's what your score sheet would be, and that's what they would hand me, and that's what I have to make the decisions on. Again, to go under that 33 point, I'm not sure what it was, 33.15 months, you'd have to convince me to do a downward departure under 921.0026. There's a enumerated A through P, I think, off the top of my head. Specifically enumerated reasons for a downward departure. An argument can be made, there's other reasons to do that, but I'll leave that to you and or your lawyer if we ever get there. But at this point, I'm going to appoint you standby counsel, Mr. Nopes. And we'll make sure to generate an order to that effect. Based on that, what would you like to do with your case today?
I would like my cell phone back.
Well, as far as what we're going to set your case for.
Oh, I wanted, but see, I couldn't, see, right now, my intent was to do joinder with my husband with his trial because it's the same incident, the same child, the same witnesses. But since it's still like we're
people
not-
have to file motions. We don't just,
Okay.
those are important things.
Right.
That you have to file motions for. And again, that's a concern.
Right.
That you've thought about that but haven't researched that, it sounds like.
Well, I knew that I couldn't file a motion before I became pro se because you can't do that until you're pro
I
se.
agree, I agree with that.
Right.
Although you could file something and your attorney could adopt it, but,
But we weren't talking at that time.
yeah, I understand, I'm just,
Yeah.
but, you know, researching these issues is important, and doing what's right for your case
Right.
is what's important, not what's right for someone else's case.
No, I believe it's the same incident, the same child, the same witnesses.
Well, then you'll have to research that and file a motion,
Okay.
or we can talk about that on the record with the state as to whether or not they agree to it. Just, we probably won't do that today because the normally assigned attorney is not here today.
Right.
And these weren't issues that were basically set for a hearing, it's just you're bringing them up now.
Right.
So I'd rather have that person here. So when I say, what would you like to do with your case? Would you like to set it for trial now? Do you want to set it for trial potentially in the next cycle? We can talk about it.
But how would I set it for trial if there's no decision on like jury versus bench? Does that matter?
Well, I think that's an important thing that you're bringing up.
Okay.
Now, we could try and talk about that. Is Ms. Leone going to be back on Monday? We could potentially talk about those issues on Monday, if you
Okay.
wanted to set it for trial this time, but you have to understand, when you say, I'm ready for trial, that means you're ready for a trial right now.
Okay.
That I have no other preparation I have to do. I don't have to track down any other witnesses. I don't want to do any other depositions. I don't want to file any other motions. I'm ready to have my trial now. And then we'll set your case for trial, potentially the weeks of March, why do I keep saying March when I mean May and vice
May.
versa? May 11th or May 18th.
Okay.
Now, I've got a few cases that are already going to be trials, so we'd have to see how everything fits into those categories or those dates, but is that what you want to do now? Or would you like to have me continue the case? We'd have you come back on June 22nd. That might give you some chance to talk to Mr. Nopes, or do some research on your own to prepare yourself now that I'm allowing you to waive your right to counsel.
Yeah, because she would be back on Monday, so that means I'd have to come back on Monday.
You'd have to
be
come
able
back on
you.
Monday and we can discuss those things if we're gonna set it for trial this time around.
Or I could come back on the 22nd
Of June.
to discuss further.
And that would give you time to prepare anything you need to prepare, file any motions, have them set for hearing.
What time, is it the usual time on Monday?
Yes, and I can, I think I've said this to you in the past, maybe not as much you as your husband, that we can give you a later time. You see, I start at 9 o'clock and I go, I haven't taken a single recess all morning to try to get through and people done before we get
Right.
to, noon.
Right.
And then, so you're not sitting here all day. I don't have an issue with you showing up later in the morning instead of sitting here at 9 o'clock.
Can I look at my calendar?
Sure.
Yeah, I think I could do this.
Would you like to kind of appear later on June 22nd?
Oh, I meant May 4th.
Oh, you meant May 4th, okay. Well, May 4th, I would need you here at 9 o'clock because I don't know how many cases are going to be on that day and how
Right.
fast we're going to go. Sometimes we're done in like an hour, hour and a half. Some days we're here all day. It just kind of depends. So if you want to set your case for trial, you can come back on Monday. And then your trial would be the weeks of May 11th or May 18th.
Okay, so my question is, on May 4th, would we be able to determine if it's gonna be a bench trial, like if she agrees to a
I
bench
can
trial?
ask Ms. Leone, that case, that issue at that time. I'm assuming Ms. Basso is gonna talk to her and leave her notes about this issue. So it's not a question, that's sprung on her when she gets here on Monday. But as you know, that there's been some different lawyers on your case. You had one prosecutor, in the other division, and then she was gonna be here, and now she's not here. So that's why Ms. Leone just got assigned your case just in the past couple of months.
Right.
So she's gonna have to make a decision on that, but I'm sure she'll be ready for that on Monday.
Yeah, because I would, that's the biggest thing is like having that done So then we can move forward towards the trial, but if that's not done, then we can't move forward, right? To trial?
No, we can't, but that could be decided on Monday.
Okay. Oh, so in the meantime, I should send in motions for
Whatever
Request
motions
the
you
bench
feel are the
trial.
ones to file.
enjoinder, and then.
I
we
don't
could
want to
just-
seem like I'm telling you to file a particular
Right,
motion.
the ones that I think.
Ms. Rolandi.
Yes, I'm sorry.
I just want to make sure it's clear on the record what I'm telling you.
Mhm.
I'm not telling you what to file, or you should file, or shouldn't file. But if
Mhm.
you're going to file anything, you should do that as soon as possible
Mhm.
if you want to go to trial this time, because there's only so much time for me to hear those motions before. That's why I typically don't want people to be filing motions after they say they're ready for trial.
Yes, sir.
Are you ready for trial?
I guess, I mean, those are the issues, so I'm ready for bench trial and joinder with my husband, but since we can't really make that decision, I guess I would say yes after going on Monday and depending on all of that. I mean, I know the witnesses, I'd have to subpoena witnesses, so I wouldn't be able to do it any sooner because I have to give people enough time to
You do.
schedule.
There's actually specific rules
the
about some
court.
witnesses, like law enforcement, have to receive
Right.
their subpoena a certain number of days ahead of time.
Right. So it wouldn't be like
And to be
ASAP.
honest, Ms. Rolandi, I'm not trying to choose for you, but I know I've got several people who have already asked for the March 18th,
May
keep
18th.
doing it, May 18th trial week, including your husband's trial is currently set for the 20th and 21st.
Right.
And I have two other cases that asked for that week as well. So most likely, if your case is not joined, then
be
you would be the
pushed.
week of May 11th, which is 2 weeks from today.
And then I won't have enough time to get my witnesses.
I'm gonna let you make your decisions on that.
Yeah, so.
But I can't let you ponder it right now. I've got other
Right,
things to
okay.
handle.
So can we set for Monday and we can at least get 2 things done that day? Because I like to get things done.
Well, if we put it on Monday without you saying, I'm ready for trial, then it won't be a trial this time.
It won't be pretrial.
It'll be what we call docket day, but we can cover some of these issues, but I'm not going to be in a situation where we're determining those things Monday for a trial this time, because you're talking about filing motions.
Right.
And again, I don't let people, you've probably heard me even here all day, how many times you
Yes.
heard me tell a lawyer, like, well, when did you file that motion? Are you gonna be filing that motion? You just
Right.
filed it on Friday afternoon,
Yeah.
before a Monday court date.
Memorandum, I heard that. Yeah, it was like.
Yeah, so
really-
you can't say I'm ready for trial when there's a bunch of pending motions. It's one thing if there are motions in limine that happen in almost every trial, but if you're filing substantive motions after you've announced it's ready for trial, you're not truly ready for trial.
I think with the motions pertain to the trial, right?
All right, ma'am, I'm gonna do this. I'm gonna
Okay.
say you can come on May 4th. I'm not getting frustrated. I've asked you the question numerous times. We can come in on Monday and we can discuss some of these issues with Ms. Leone, the prosecutor, when she's here, the
Okay.
normal one who's assigned to your case.
Yes.
But I'm not gonna set it for trial unless you're doing that and you're saying, yes, I'm gonna be ready for trial May 11th.
Okay.
So it'll be May 4th. That'll be a soft date, which means they're not gonna send out subpoenas for a trial. And if you ultimately decide you wanna go to trial, we can set that on June 22nd. Another pretrial will announce where that trial will be in July,
Okay.
okay? And I can tell you, as far as the July calendar, we only have 1 week for trial as opposed to 2 that month. I announced that back in December, I think it was.
Okay.
That I won't be available for the second trial week. So there's only gonna be 1 trial week, so it's gonna be hard to get a lot of trials in that time as well. I'm just trying to give you all the same information I gave to the lawyers in my division 5 or 6 months ago, because it's just important, and I like people to know that information where it's not being sprung on them at the last minute. All right, we'll see you on Monday, May 4th at 9 o'clock.
I do have one other thing, if I'm able to address it. It's my phone.
What is your phone? You've got a phone in your hands that you're reading.
It's the one that was taken as evidence, and
Okay.
they have.
Have you filed a motion for it to be returned?
No, I was gonna, see if,
I don't know if the state plans on using it as evidence, you're gonna have to file a motion.
they already stated that they downloaded all of the information.
I understand, but what are you asking for? The physical phone to be returned to you?
returned,
You're gonna have to file a motion for that.
Okay, all right,
All right.
thank you, Your
Thank you,
Honor.
Ms. Rolandi.
Oh, sure.
What is this? All right, was there anyone else on the 9 o'clock docket? Ma'am, who are you? Smalley? Jessica Smalley. Is she on the docket? Can you spell it? Smalleen, okay, now I got it. Do y'all see her anywhere? You're at 1 o'clock, ma'am. You have a public defender? I show that Ms. Rivers has been appointed to your case. You filed an application, right? Okay, you were appointed Ms. Rivers. She'll be here at 1 o'clock. Y'all have anyone else? Okay, Mr. Rolandi, I think you're at 1. That's, it's not about changing my mind, sir.
It's up to you.
I show 4:27 at 9 a.m. All right, come on up, Mr. Rolandi. Oh, wait, hold on a second. I'm looking at the wrong Rolandi. I'm showing the clerk's minutes from March 5th. Say, that's when we came up with the bench trial date for May 20th and 21st, right?
Yes, sir.
Take your hands out of your pockets, please. Now, if you could approach the podium, just so you're picked up by the microphone.
Call me or not, you were
I
gonna
know,
set me
well, I'm
back.
addressing you. I want to make sure you're heard. At that time, we said April 27th at 1 PM for pretrial conference, and that you could appear at 3 o'clock.
That's not what we were said, what we said. We said 9 o'clock, but it's up to you, Your Honor. I see.
I can
when
go
you're
pull
gonna
the
see me.
video if you'd like, Mr. Rolandi.
You don't need to do all that. If you want to see me at 1 o'clock, that'll be fine, sir. I'm at your leisure.
All right, we'll handle your case right now, Mr. Rolandi. What are we doing with your case? It's set for trial May 20th and 21st.
That's all, Your Honor.
All
I have
right.
nothing to say.
State have anything? All right, and I know that's the date that we set last time to make sure everyone was prepared. We'll see you on May 20th.
Thank you very much,
Well, hold
sir.
on. I think we still need to see you for the review date.
Yes, Your Honor, we
Okay.
definitely need to do a date.
So that would be Friday, May. Second?
Be the first.
May 1st. All right. No, it's next week. May 8th. Okay. I was going to say, I'm handing a mock trial for some students that day. I hope I didn't schedule that. All right, so it'll be May 8th at 9 o'clock will be your review date, just to make sure everything's ready for trial. Subpoenas are out, they've been served, everyone's ready to go.
They've been served.
Okay, well, both sides. You have to understand there's two sides of every case.
Sure.
Okay. Sure?
Yes, sir.
Okay, all right, we'll see you May 8th at 9 o'clock for your review.
Thank you, Your Honor.
Thank you, have a great day. Anybody else? All right, we'll be in recess until 1 o'clock.